we are going to file a in return. The petition is ready, but the petitioner cannot sign the affidavit due to his illness. Needs 3-4 days.
I'm appointed private hospital.
2018 matter. When did they file the affidavit?
Next 3 or 4 days.
When did they file the affidavit?
I filed on 26/6. 26/6.
26,
6.
16.
6.
26.
26th of June, Milord.
Of this year. And what is the matter about?
Then acquisition matter lordship. Then acquisition for the national law in Pakistan.
Yes. Okay. Item number 7. At the request of the learned counsel for the petition of matter stands adjourned to be listed after 6 weeks. In the meantime, they should file the affidavit. Yes.
My name may be recorded. Otherwise, nowadays all are passing by the students. So my name will be.
Give your names, the name will be recorded.
I'm Mohan for private.
Hmm?
I'm Mohan for private.
Lordship, I would like to mention item number 10 and 11, Your Lordship.
Yes.
Your Lordship, we are instructed to withdraw the matter. Your Lordship.
Huh?
We are instructed to withdraw the matter.
10 and 11.
10 and 11. There's an analogous matter with item number 9. We are only for 10 and 11.
Who is appearing for item number 9? We'll take it up at the.
All right.
So, Lordship, I have to mention item number 29. Kindly adjourn for the.
The request of the learned counsel for the petition and matter stands adjourned to be listed after 6 weeks.
At the Lordship, I beg to mention item number 21. Lordship, from 21, we didn't receive any instruction. We didn't receive any instruction. The matter is related with settlement of land.
We'll take it up when the matter is there. You see,
I beg to mention item number 3. I have instruction that this already
infectious. The learned counsel, Mr. So-and-so submits that he has instructions to withdraw the instant petition, taking into account that the relief sought for have been granted. Taking into account the above, the instant petition stands closed on withdrawal. Interim order, if any, stands vacated.
Lordship, I beg to mention item number 2. Lordship.
2?
22, yes.
Yes.
I think hope that this matter, also then, this matter has become infectious.
Infraction. Mr. So-and-so, the learned counsel appearing on behalf of the petition, submits that he has instructions to withdraw the matter, taking into account that the petition has become infructuous. Accordingly, the interim the petition stands closed on withdrawal. Interim order, if any, stands vacated. Yep.
I don't know what I missed.
Forward is not here. Forward is not here.
Yes, madam, you got the instructions out here.
Received instructions, they are on the way coming from the office.
We'll take it up sometime.
But the item one,
None appears on behalf of the petitioner on call. It further appears on the earlier occasion also. None has appeared on behalf of the petitioner. Be that as it may. None appears on behalf of the petitioner on call. The instant petition was filed by the father of the petition, by was filed by the petitioner, stating inter alia that his son, one Abdullah Sheikh, alias Abdullah SK, was kidnapped by the miscreants on 15/10/2016 at about 3 p.m. Thereafter, it was alleged that on 25/10/2016, some unknown persons demanded an amount of ₹12 lakhs for releasing the son of the petitioner, else threatened to kill his son if the said demanded money was not paid. Under such circumstances, the petitioner lodged an FIR before the Fakirganj police station, which was registered as Fakirganj PS case number 258/2016 under section 365/384 of the Indian Penal Code. Subsequently, the said case was re-registered under section 302/201 of the Indian Penal Code. And subsequently, in the said case, 2 other sections were added, that is section 302/201 of the Indian Penal Code. The petitioner herein applied for compensation before the Deputy Commissioner Dhubri on the basis of for grant of ex gratia compensation to the next of the kin of the victims killed by extremists of the miscreants, as well as also the compensation scheme as per section 357A of the Code of Criminal Procedure. for providing compensation to the victims. The petitioner therefore requested the respondent, requested the Deputy Commissioner Dhubri to pay appropriate compensation of rupees 3 lakhs to 9 lakhs under the government notifications as well as the Assam Victims Compensation Scheme. The petitioner thereupon had also approached the Chairman, District Legal Services Authority, Dhubri, making similar prayer. However, as no compensation was paid to the petitioner has approached this court by filing the present writ petition. It reveals from the records that by an order dated 24/7/2017, notice was issued The report further reveals that the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, had filed an affidavit in opposition through the Deputy Secretary of the Revenue and Disaster Management Department. In the said affidavit, it was mentioned that cases of missing persons due to kidnapping by miscreants are not covered by the government's letter number ABP.121/92/PT-5/136 dated 22/6/2004 and the notification number RR.69/2044/16 dated 14/12/2004. It was further mentioned that the government had revised the ex gratia amount from rupees 1 lakh to 5 lakhs with effect from 15/11/2014 in respect of persons whose age is 18 years or above, killed or kidnapped by extremists or terrorists or miscreants on or after 15/11/2014 in the state of Assam. And the revised rate is rupees 3 lakhs in respect of persons whose age is 18 years. It was further mentioned that there is no scheme, public provision to provide ex gratia grant to the next of the kin of a killed person as a result of a private dispute. It was further mentioned that it was not possible on the part of the Revenue and Disaster Management Department to release ex gratia amount without receiving proposal from the concerned Deputy Commissioner, along with all relevant reports like the SP report, magistral inquiry report, etc. Yes, who is appearing for the government? You are appearing for the Deputy Commissioner. What is your stand? Because here they are saying, here is a case where the FIR was filed and initially it was under 384, 365 and 384. Subsequently, it was converted to 302/201. So under such circumstances, would he not be entitled to the benefits under the scheme of the notification? Because what has been mentioned, and Mr. Bhattacharjee, your affidavit stipulates that you don't give for private dispute. But a person having been kidnapped by miscreants, wouldn't he come within the ambit of this? I've heard the learned counsels appearing on behalf of the Deputy Commissioner Dhubri as well as the Revenue and Disaster Management Department. This court have also perused the notification dated 15/11/2014, wherein at serial number 1, ex gratia grant is paid to the next of the kin of a person killed and whose bracket the person's killed bracket whose age is 18 years or above by extremists oblique terrorists oblique miscreants. Other than being killed as a result of a private dispute. The petitioner, from the materials on record, it transpires that the petitioner had duly submitted representations before the Deputy Commissioner Dhubri. The stand of the Deputy Commissioner Dhubri is not placed before this court. But when a representation is submitted on the basis of making a claim for ex gratia, the Deputy Commissioner, it's a bounded obligation of the Deputy Commissioner Dhubri to have made necessary inquiry into the same, and thereupon, if entitled to, should have forwarded it to the Revenue and Disaster Management Department so that if entitled to, as per the notification dated 15/11/2014, the ex gratia payment can be paid to the next of the kin. As there has been as the stand of the Deputy Commissioner Dhubri have not been placed before this court, it is therefore not known as to what steps the Deputy Commissioner Dhubri had taken pursuant to the representation submitted by the petitioner. Taking into account the above, this court therefore disposes of the petition with a direction to the Deputy Commissioner Dhubri to make necessary verification as regards the case of the petitioner, as regards the entitlement of the petitioner. In terms with the notification dated 15/11/2014, by taking due note of the Fakirganj police case number 258/2016. The officer in charge of the Fakirganj police station is further directed to apprise the Deputy Commissioner Dhubri as regards the investigation so carried out in respect to Fakirganj PS case number 258/2016. The Deputy Commissioner Dhubri thereupon, after making necessary verification, shall send the proposal, if found entitled, if found eligible and entitled, to the Revenue and Disaster Management Department of the Government of Assam. The respondent number 4 thereupon shall take appropriate steps for disbursement of the amount to the petitioner, if found entitled to. The entire exercise be carried out within a period of 3 months from the date a certified copy of the instant order is served upon the petitioner, upon the deputy commissioner. Dhupri. I put it non-appeal for the petition. You want your name, pay 10,000 to the advocates fund, it will come. Otherwise, no.
Lordship can take up the item number 1.
Yes.
Instructions not to be have.
Item number 1.
Hey, Nandu, where do you go? Yes, what did you find? Who got non-appeal? Yes, what happened? Is it still pending investigation? Why does it take such a long time?
Still undressed.
Huh?
Person is still undressed. Unable to praise him out. Depending on the basis of the affair, the person sponsors the arrested nothing came out.
The instant petition has been filed by the petitioner, seeking a direction upon the respondent authorities to conduct proper investigation of the case being Pragjyoti School PS case number 75 of 2016, registered under section 120B/365/341 of the Indian Penal Code, and to trace out the missing son of the petitioner, namely Kulendra Kolita, and to produce him or his corpus before this court. It appears from this court, by an order dated 29/9/2023, had directed the government advocate to apprise this court as to what, apprise this court as regards the investigation so carried out in respect to Pragjyoti School PS case number 75 of 2016. Today, Mr. H. Sharma, the learned counsel appearing on learned government advocate appearing on behalf of the respondents, have placed the status report of Pragjyoti School PS case number 75 of 2016. From a perusal of the said status report, it reveals that various persons, various witnesses have been examined and recorded, and their statements recorded. The FIR accused persons, namely Horen Kolita, Mrs. Bondana Kolita, Probir Borbora, Mr. Probir Borbora, have been arrested and forwarded to the judicial custody. It has been further mentioned that the case is under investigation and pending for trace out of the victim of the missing Kulendra Kolita, and to further investigate the case. The said status report is kept on record and marked with the letter X. taking into account that there has been investigation carried out in respect to Pragjyotispur PS case number 75/2016, and the said proceedings and further investigation is going on. It is the opinion of this court. This court, after perusal of the status report, is satisfied that the officer in charge of the Pragjyotispur police station have been carrying out the investigation as per the mandate of law. So, under such circumstances, this court finds no reason to keep the instant writ petition pending. However, this court disposes of the instant writ petition with the direction to the officer in charge. Where did this happen? Pragjyotispur PS is where?
So the
It would be under which higher officer? Commissioner?
yes, yes.
Commissioner of
And
Guwahati?
he's a party here.
Commissioner of Guwahati
Yes, Commissioner of Police. Guwahati.
disposes of the instant writ petition with the direction to the officer in charge of Pragjyotispur PS police station to carry out the investigation in respect to the Pragjyotispur PS case number 75/2016 and bring it to the logical conclusion at the earliest. So, this court further directs the Commissioner of Police, Guwahati, to also take appropriate steps and ensure that the officer in charge of Pragjyotispur police station is carrying out the investigation as per the mandate of law. A copy of the instant order be served to Mr. H. Sharma, the learned counsel, appearing on behalf of the respondent authority, for forwarding the said order to the concerned officers for needful compliance.
Five.
Yes, what is this?
Statement of
Railway women?
Vehicle, my lord.
Hmm.
So it was, excess load was detected.
Then
That is after 1.5 years. So when
declaring that the impugn notices of demand issued by the respondent are illegal and constitute ultra-virus and accordingly liable to be set aside as to why. Why are you challenging these notice, the demand notices?
This is artificial, because there's a judgment the lordship has that's the key that technical and religious studies.
Hmm.
They passed the notice.
Why? That was done for another purpose. There was no opportunity given for the purpose of reweighment,
Yes.
which is given under 78 or 75, 70, 73. No, reweighment is what? Under 74?
Yes. 79.
79, yes. So 79 is the section by which a right is conferred upon these persons. Now, here is a case where they have taken the goods,
But they have only 1.5 years back.
and thereupon, why have you sought to realize from them certain amounts after 1.5 years?
Instructions in this matter. That the women, that the son of women mother, that was, women was made within time. And the start of women mother, there was the late the delivery of that matter to the intersection. Therefore, matter, it was on receipt of this chart matter that he has enclosed the chart in case 25. The women said the repetition case 25. It is not in issue that excess weight was found.
Huh?
Case 25.
Yes.
249.
Hmm.
Total homes, marine homes,
Hmm.
excess weight was detected.
Where?
Based on the last month.
No, where was it done? This was a consignment from which place to where to where?
So it was, the women was done in Malta.
And consignment from where?
Consignment from Kalgaon to Mokazam railway station.
Kalgaon to Bokazar. And in the at that point of time, it was done at the
It was
this
done on
the railway receipt said to be weighed at per. What does the railway receipt say?
It is said to contain.
Said to contain. Said to contain, then it will be his.
It is his duty to prove.
Prove.
It is otherwise it's correct.
Okay.
But
Now, if it is a said to contain,
we are entitled to wait.
absolutely. So in midway, you have weighed it. Okay. When you in the midway, when you weighed it, did you inform him about this weight? Thereby, you are taking away his right to reweighment under 79. That's your case.
It was loaded, unloaded on 21/2007 and they even
21?
21/2007
Okay.
and it was informed to us on 2/8/2000.
2008. This document, Annexure 3.
Annexure 3 Malay is dated 22/7/2007. No,
Understood. How did you get this document, Annexure 3?
that is page 23 Malay. You have received
You're on page 25.
page 24.
How did you get this document?
This has been given to us.
When?
Along with that letter, it is,
Have you mentioned it?
I have not mentioned.
Then if you have not mentioned it, it will be presumed that you have been given at that point of time.
No, not that.
What?
Moreover, my lord, one submission, my lord. So far, this increase as a concern, my lord. Reserve funds to be executed before. My lord, the tribunal, my lord, railway claims tribunal is there. Section 13. Railway claims tribunal 1987.
Where did you get this notice of the women report?
It says, my lord. In this 12, my lord, there are starting with a consent reading, my lord. There he has stated about this one.
No, he has stated at parallel number 6 also.
Yes.
Why this statement is categorically not mentioned that you got this weighment along with the notice of demand?
Since, my lord, this,
Because your entire case is, as I don't know the women. So I didn't ask for it. But if you don't make that specific statement in your petition, how can this court adjudicate that? Isn't that your specific case? Or do you have anything else?
It was not done, when the books were on, vacant.
Prior to your unloading, they should have informed you about the reweightment.
That's fine.
Now, this reweightment has been made and this is the annexure 3. Why haven't you made a categorical statement that this document I have only received at the time when the notice was issued?
My case, entire distribution has been.
Because that is your case.
Yes.
Then, so your statement has to be clear and categorical. And if it is not there, Mr. Das is going to the division bench. If I pass an order in your favor. And when did you inform him about this payment? You file an affidavit. State when did you inform? Because that document, although the petitioner, I don't know, maybe a problem with the drafting of the petition. But from annexure 2, more particularly not the type 2. The type 1 is horrendous, typed out wrongly. They don't know the difference between sheet and sheet. The person who has typed out. And the manner in which a person has made it certified to be true is also requires condemnation of the highest order. Who has done this? Who has filed this petition? In this manner?
Long time back.
Long time back doesn't mean that that means you are a senior counsel now. So you can't take the responsibility out there. Now, who has done it? You only appear upon instructions. Now your instructions are wrong. Why should this court not dismiss the writ petition on that count itself? That a certification which has been done by the council is not there. Is not there. Mr. Roy. Then the petition should be dismissed. How can we take a note of all these documents at all? If it is not there, because otherwise this certificate becomes useless. We dismiss it on that ground. If that person is not appearing, where is he? We put him to the bar council notice. This is the best way to do. Because you see, you cannot say, as now you are a senior counsel, you have no responsibility over the client. Do you have? No. If you have, then that would be going against the ethics. So you don't have. The only one who has is the counsel where the drafting counsels as well as the person who has signed it, who has filed it, and he is not there. So we dismiss it on that now. Huh? Retype it. Let us read what is annexure 2, what you have typed out. At page 23, read it.
Response to the above cited complaint, the apply and book for Kalaikon to Okada under invoice number so and so, which has released under charge of 12,09,755 as maintenance. Found this as chart which is shown in the report E-sheet for the impact. E-sheet.
Sheet. What do you mean by that? Huh? No, page 23. Not 24. What is this E-sheet?
Maybe enclosed sheet by law.
No, you cannot say.
How to take it?
We dismiss it on that ground. Pay that amount. on the electricity. And what were you saying about an alternative remedy?
Yes, Maluk, actually, Maluk, this punitive size and all that. This is in regard to looting and unlooting and the overlook. So in respect of that, Maluk, jurisdiction lies before the Maluk, Railway Crimes Tribunal under section 13 of Railway Crimes Tribunal in 1987. And
He is going to file.
Maluk,
Can he challenge in the Railway Claims Tribunal any notice to pay? Can he challenge?
no, he has.
If you impose upon him, then he can make. If you already have recovered from him, he can make a claim. So the moment you issue a notice, can a notice be put to challenge in the RCT? No. Can it be possible?
Because imposition, Maluk, the amount has been determined. Whether excess weight is there or not, Maluk. Whether
Are you saying that he can challenge it in the,
he can approach before the.
maybe no,
Yes,
he can,
he should.
no, he should not, he can,
Yes,
he can,
he can challenge.
let's see. On Railway Claims Tribunal. Taking into account that you don't have your advocate on record, it has been done improperly in this manner. We relegate you to the Railway Claims Tribunal, go there. And when there is no statement made in your petition, there is no categorical or single statement out there in your petition. Yes, yes. Railway conduct.
One. Under section 65 by railway receipt, we put the articles, therefore it is an enforcement in respect of animals or food entrusted to the railway administration to be carried by railway. 13(1)(b). So these articles entrusted to railway for carrying, and there we found under section 73 the overall weight. So since as per railway receipt 65. So this issue involved upon the railway receipt under the heading of safety content. So in such cases, 13(1)(b) under that section. But this honorable court may not like to interfere.
No, but what about his right to weigh?
That may be out of the before the tribunal.
Why?
Yes. whether notice has been given or not given, my lord, because in other cases we also found, my lord. If the
Mr. Roy does not go to the RCT, then
My lord.
you want to take away the brief from him.
Sir. Is that?
Then what do you say? Be humanitarian. Mr. Roy does not go there. You,
But since women, is not, calculation is not disputed.
Huh?
Re-women is not disputed, and there are,
no. Kindly come to annexure 4A, page 28. I think these people know better than the lawyers who drafted the petition what to put. Page 28.
section is considered.
Why? Why should I direct? No, first, if you have taken away his right to rewayment and giving him after 2 years, then
But the judgment is not with me right now, madam.
why do you need the judgment? Have I seen the judgment? I am not.
Here, madam, honorable, at the High Court, madam, has said that if notice is not yet received, but in the Supreme Court judgment, madam, there it is stated, since section, madam,
You are referring to 1998 for SCC.
73, madam, yes. Since section 73 does not provide for issuance of notice.
Not necessary. Notice is not necessary.
Like, madam, is for honorable Supreme Court.
Understood. No notice is required. But what about his right to reweigh? Which is a statutory right.
Perhaps if it is communicated, madam, within time, madam, the re-women seat, madam.
That should have been, which you have not done. After 2 years you have given.
So, madam, so for his calculation, madam. After
Whatever may be, if you have taken away his right of rewayment, how can you have it? Mr. Roy, after this matter, the judgment, this is, you are referring to Justice Talapatra judgment?
Yes.
The matter went to the division bench. What happened thereafter? And in fact, it matter, there is a full bench decision also on that. What does it say?
it support that, the judgment. Madam.
Yeah, it's the full bench. No, this judgment does not say that. On the question of reweighment, that judgment is that. I think there was an appeal against that. Where is the judgment of Justice Talapatra? They have not got Justice Talapatra's judgment. You are referring to paragraph 17. Will impose cost on you, on the council, for not properly making the petition or drafting, and not only that, certified by true copy is not being done in a proper manner. Yes, what do you want to say?
Just one submission, madam.
What submission?
I am referring to section 79 of Railway Act. So
Yes, what does it say?
79, madam.
Ah,
Second, proviso, madam, first proviso, provided that except in case where railway seven authorized in this behalf considered necessary to use, no wetland shall be allowed of goods cooked at owner's risk. Okay.
Hmm.
Madam, say to content in the owner risk.
Hmm.
Madam, since the district under section 65 is need to content, madam.
Hmm.
So therefore, possible. Can you consider?
where provided that, provide for us that no request for payment of consignment
No,
in
before that.
wagon load or train
Before that.
loads, huh?
Before that, provided, first
Ah.
provided. Provided except case, is
Where railway survey authorized in this behalf consider it necessary to do so, no payment shall be allowed of the goods booked at owner's risk. or goods
Or-
which are perishable
or-
and are likely to lose weight in transport.
No, that is all. So, madam, this is one line, madam. No equipment shall be allowed of goods who at owner's risk a day. Another section says that no, receive itself says that save people. But in such cases,
Says, provided that except in cases where a railway servant authorized in this behalf considers it necessary to do so, no weighman shall be allowed of goods booked at owner's risk. So, when will the railway servant be,
madam, madam,
may consider it necessary?
for that, madam, first, provision. A railway administration may all the requests made by the consignee or endorsed. Allow weighman of the consumer subject to such condition and on payment of such services. As may be prescribed when the demerits. So another request. Now, I would also take instruction on that. My submission is. that-
There is no more instruction. We have already spent so much of time. What else do you have to say? No, yes. Here in this case, the coordinate bench has held it about 79, saying it is not automatic that you cannot ask. The railway servant, you may ask the railway servant and the railway servant may refuse.
Right.
But this power or this request which is being made, you are not allowing him to make that request also. What you are saying today, if we allow it, then tomorrow, if we don't interfere with these, tomorrow, anything done under owner's deed, railway may ask any amount. He has no option. Can he? Can he today, after taking the delivery,
Yes, madam, because madam, kindly say, madam, if this requirement is, madam, furnished, madam, consent. Then they are, madam, that for the time. And then on receipt of the, so, having found the difference of the weight, the request then has to be come from the, madam.
when will he know? Unless you give him. You have done it on the midway. Have you asked him that we are going to do it midway? If he was present at that point of time, it was different. But he was not informed. So how will he know? One fine morning after 2 years, you come up and say, look here, we made that payment there. It has received us, we received it now.
Madam, what happens, madam, is immediately after payment, because payment is done in the church. So before the destination, madam, this is communicated. This women's service communicated, this is the difference.
So that should have been done. Why did it take 2 years for you?
2 years for the calculation, because
What calculation? Does it take so much for your calculation for 2 years? My goodness. Does a person get the job out there in the railways? We have the statutory auditors. The railways have a complete set of their financial analysts and all these things. They have it. And they take 2 years for making a calculation that there was an overweighment of 249 tons, and it takes 2 years for them to calculate how much it should have been. My goodness. Mr. Das, I think you should put this on affidavit. It took 2 years. Are you going to do that?
One of the,
Tomorrow it may be a headline in Times Now. Hello, enough. That cost 10,000 on the council.
one of the,
10,000. Which one? Consider what? I have given you such a patient hearing. That is the most consideration I have done. Nothing more. Huh?
From the date of my engagement in this case. This is the first time this method has come out.
So, how much time you have taken for reading it? You must have read it in the morning today. Oh, fantastic. I saw this when Mr. Roy stood up. The instant writ petition has been filed challenging the notices of demand dated 2/8/2008 and 27/1/2017. Huh? Is it proper? Why there are 2 notices? What is this 2017? What is that? Reminded you? It's the same amount for the same women. Huh? No, these are different. No, all are different. Kindly see page 36. The last one you must be punitive charge for 2007. Well, others we are not interfering. Only to that. Challenging the notice of demand dated 2/8/2008 as well as the notice of demand dated 27/1/2017 issued by the respondent number 5. The relevant facts of the instant case is that the petitioner, who is engaged in the business of manufacturing cement. You manufacture cement. Manufacturing cement. Manufacturing and sale of cement had procures a commodity by the name of fly ash from various sources, which is an essential material for manufacturing cement. The instant writ petition pertains to the consignment of fly ash booked from Kaholgaon or Kazolgaon. It's very difficult. Huh? Yeah. Kaholgaon to Bokazan railway station by RR number C147943 dated 21/2/2007. The said railway receipt have been enclosed as Annexure 2 to the writ petition, Annexure 1 to the writ petition. Annexure 1 to the writ petition. A perusal of the said railway receipt reveals
Left side of the straight to contact.
page,
Left side of the this one,
page 22, where?
straight to contact, left side. Number and description on parts, side to contact.
That the act is deviance that the weight as declared by the petitioner was 2482.90 tons. And an amount of rupees 23,89,403 was paid as the charges. Further to that, it is also seen from the said Annexure 1 that it was mentioned that there was a remark, inverted comma, said to contain 80125 dry fly ash as per forwarding note, inverted comma closed. Please, we are setting aside this. The said consignment upon reaching the Bokajam railway station on when received at Bokajam railway station. No. The said consignment reached the Bokajam railway station on 24/2/2007, and the railway authorities permitted the petitioner to unload the said consignment of fly ash in relation, which related to the railway receipt number C147943 without exercising any lien over the said goods. It is also an admitted fact that the reweighment, the admitted fact that prior to releasing the goods, prior to unloading of the goods, the railway administration did not issue any demand notice, nor informed about any reweighment done during transit. Next. On 2/8/2008, a notice of demand was issued by the respondent number 5, intimating the petitioner that the petitioner is liable to pay an additional amount of rupees 12,09,775 as punitive charges on the ground that on reweighment done at Railway Weighbridge, Malda, it was found that in respect to the consignment pertaining to invoice being RR number C 147943 dated 21/2/2007, there was an overweighment there was overloading of $249.76 tons as per the E/sheet SHEET enclosed to the said notice of demand. The petitioner was thereupon asked to make payment of the said amount लेकिन 2/8/2008 issue করেছে notice of demand had issued a notice of demand লিখে দিব 2/8/2008 এই paragraph 2/8. It is not known what transpired thereafter, but on 18/3/2010 the Deputy Cement Manager, Deputy General Manager Production of the petitioner had issued a communication to the Divisional Railway Manager C stating inter alia that denying the allegations made in the notice of demand and further stating that there might be a mechanical error in the weighbridge showing abnormally high weight, which is practically not possible. It is further seen that thereupon, by another communication issued by the manager of production, an appeal/request was made to write off the undercharged amount of ₹12,09,775 on the ground that the undercharged amount was received by the petitioner after a lapse of more than 2 years. It was further mentioned that at the time of delivery of the wreck, the weighbridge weighman sheet along with the RR was not received, nor any error sheet as mentioned in the claim by the Railway Authority. Under such circumstances, it was again requested to write off the undercharge amount of ₹12,09,775. It is further seen that subsequent thereto, another communication was written on 10/1/10/2015 by the manager, by the HOD production, requesting to waive off the amount of rupees waiver various amounts, including why have you enclosed this? Including the punitive charges on the basis of RR number C147943 dated 21/7/2007. Although such representations were submitted by the railway administration, did not accept the request of writing of the amount of rupees 11,11,662. Which was the amount later on found by the railways. Subsequent thereto, by another communication dated 27/1/2017, which have also been put to challenge here in the instant proceedings. The petitioners were again directed to pay the amount of rupees 11,61,687 along with other amounts. The learned counsel, senior counsel appearing on behalf of the petitioner submits that the notice dated 27/1/2017 has been challenged only to the extent of the punitive charges of 2007 and not in respect to the other amounts. In view of the said note imposition of the punitive charges on the ground of overloading in terms with section 73, and thereby denying the right of rewaivement, the instant writ petition has been filed challenging the demand notices as already referred to herein above. It reveals from the records that by an order dated 26/7/2017, this court had issued notice and state the notices dated 2/8/2008 and 27/1/2017. A period of 6 years had passed by, but the railway administration did not find it necessary to file the affidavit in opposition. I've heard the learned counsels for the parties and have also perused the necessary materials on record. The issue which arises for consideration is twofold. Is as to whether the railway administration could have issued the demand notice dated 2/8/2008 after a period of 2 years, after a period of more than 1.5 years from the date the petitioner had taken delivery of the goods in question. Mr. J. Roy, the learned senior counsel appearing on behalf of the petitioner, submitted that the issue involved in the incident with petition is squarely covered by a judgment of the coordinate bench in the case of internet lining. আপনাকে ইন্টারনেটে মানুহকেইটা কৈছো ইমান শ্লো হলে নহব ন slow. Covered by the judgment of a coordinate bench in the case of Megha Technical and Engineers Bracket Private Limited versus Union of India, WPC number 1262/2011. By the judgment and order of the coordinate bench dated 6/8/2012, passed in Megha Technical Engineers versus the Union of India and others, report WPC number 1262/2011. In that regard, the learned counsel has drawn the attention of this court I relied upon paragraph 17 of the said judgment paragraph 16 and 17 of the judgment, wherein the coordinate bench of this court had framed the point of determination as to whether the railway authorities can raise the punitive charges for overweighment after the delivery of consignment is caused, and whether the lien can be presumed after the delivery of cause in view of section 83 of the Railways Act 1989. Paragraph 17 of the said judgment, being relevant for the purpose of the instant dispute, is quoted herein below. From a perusal of the said judgment, the above quoted paragraph, paragraph 17, 18, and 19 of the said judgment being relevant is quoted herein. From a perusal of the said paragraphs, it transpires that it was held by the coordinate bench that it would not be open to the railways that held that when the delivery is made to the consignee at the point of destination, and no penalty for overloading is raised before such delivery, it will not be open to the railways thereafter to demand penalty or to seek any lien over any future consignment for the purpose of such penalty. It was held by the coordinate bench that on a harmonious construction of section 73, 79, and 83, the position that emerges is that the railway cannot seek the demand of penalty in respect of consignment after consignment has been delivered. It was therefore held that it was therefore held by the coordinate bench of this court that the imposition of punitive charges as raised by the notices of demand after the delivery of the consignment, and that too without raising any lien, have rendered the action of the respondent railways wholly illegal and unsustainable. Now, coming back to the facts involved in the instant case, it would be seen that on 24/2/2017 itself, 24/2/2007 itself, the delivery of the goods were taken. The railway neither provided the petitioners with the weighment, the reweighment sheet, or issued any demand notice prior to the delivery, or even at the time of taking delivery. The railways also, at the time of taking the delivery, never exercised its lien in terms with section 83 of the Act of the Railways Act 1989. Under such circumstances, the demand notice so issued on 2/8/2008, that too after 1.5 years, enclosing therewith the weighment sheet for the first time to the petitioner, is contrary to the provisions of section 73, 79 and 83 as held by the coordinate bench of the Scott in Mega Technical and Engineers Private Limited, Supra. Accordingly, the demand notice stated 2/8/2008 is set aside and quashed. In view of the setting aside and quashing of the demand notice dated 2/8/2008, the resultant notice of 27/1/2017 insofar as imposition of punitive charges of an amount of rupees 11,61,687 is also set aside and quashed. This court, however, clarifies that as regards the other amounts specified in the notice of demand dated 27/1/2017, this court is not interfering. With the above, the instant petition stands allowed, subject to a deposit of a cost of 10,000 by the senior counsel to the advocate fund. No, this type of cost has to be given. 10,000 will be less for you. Make it 15,000. Cost to nalage for the first time. Yes, madam, what is your instruction here?
Section is not yet received. In fact, I am not going to work with the responsibility.
Response number?
4. Other referring department is given the direction number. And as per competitive fight by
Who is appearing for PWD? You are appearing for response number 4. Yes, you are the competent authority. What is your instruction as to whether you have paid the compensation or not? The instant petition has been filed by the petitioner. Being aggrieved by the non-payment of compensation of the amount for the land acquired and the damage of the RCC G+2, G+3 commercial buildings of the petitioners, as estimated by the authority for the purpose of construction of the NH 15/52 in village Bandodua under Narayanpur Revenue Circle in the district of Lakhimpur. This court, by an order dated 10/11/2017, has issued notice. However, till date, The respondent number, the respondents, more particularly the respondent number 3 to 6, have not apprised this court about their instructions or even filed any affidavit. Though almost 17 years have, 6 years, almost 6 years have passed by. This court fixes this matter again on 18/10/2023. The learned counsel appearing on behalf of the respondent number 3 to 6 are directed to apprise this court as regards the instructions. Failing which, this court shall proceed on the basis of the materials available on the court.
Okay.
The last of the event. Also, there is the last.
In Old Act 687.
Now they are telling you that.
Here the allotment has been made,
Settlement,
settlement done.
settlement has been made, page 18, right?
No, it is only an allotment.
What?
It is an allotment. You have paid the year. They have not issued the periodic lease.
No.
So settlement has not been given. So you have land. Why you are not giving it? Issue a settlement. He has already paid that amount. We dispose it of. You are not in possession of any land. So they will give you. How much time? The instant petition has been filed by the petitioner, being agreed by the inaction on the part of the respondent authorities in not handing over the possession, in not granting the settlement of the land in favor of the petitioner by issuance of a periodic lease, as well as also for not handing over the possession of the land measuring 1 katha 10 lechas, covered by tag number 687 bracket part, situated at village Hangrabari under Moza Beltola in the district of Kamrup Metro, Assam. From a perusal of the materials on record, it reveals that the revenue bracket settlement department of the government of Assam had, by the communication dated 4/3/1993, conveyed that the governor of Assam was pleased to order for settlement of 1 katha 10 lechas of land, of Sarkari land, covered by dag number 687 part of village Hangrabari under Beltola Moza in favor of the petitioner and his wife in the joint title of the spouse for residential purpose subject to payment of 100% land value as premium. The land value was fixed at rupees 15,000 per katha. Apart from that, by the said communication, it was also mentioned that the possession of the land may be handed over and the land records be corrected on receipt of the due premium from the petitioner in full. It further transpires that by another communication dated 11/5/1993, it was mentioned that the earlier communication dated 4/3/1993 was modified to the extent that the petitioner would get 25% exemption on premium payable to the government as he belongs to the scheduled caste. The records further shows that the petitioner on 15/6/1993 had duly paid the amount. You paid? Yes? You paid the entire amount? Huh?
Yes.
First installment, second. Have paid the amounts, the due premium on 15/6/1993, 27/9/1994, and 12/12/1994. As is apparent from annexes C1, C2, and C3 in 3 installments. What did you say, page 25? And your name is there?
Yes, my lord. 79.
Hmm?
Yes, 79.
It further reveals that the petitioner thereupon have been pursuing with the respondent authorities for the purpose of handing over the possession and correction of the revenue records in respect to the allotment of 1 katha 10 lechas of government land covered by Dag number 687 part of village Hengrabari under Bentola Moza. In spite of representing before the respondent authorities time and again, as the respondent authorities did not take any steps, the petitioner have been compelled to approach this court by filing the instant writ petition. This court, by an order dated 21/2021, issued notice. The respondent number 6, that is the Circle Officer, Dispur Revenue Circle, Kamrup, had filed an affidavit in opposition. Paragraph 4 of the said affidavit in opposition being relevant, paragraph 4 and 5 of the affidavit in opposition filed by the respondent number 6 being relevant is quoted here in under page 35-36. From a perusal of the said paragraphs above quoted, it is seen that the old government Dag number 687 have been renumbered as new government Dag numbers 3335, 3337, 3373, 3374, 3375, 3376, 3378. এইকেইটা বহুত কেইটামান আছে গৈ পেলাই লাষ্টত আছে 3391 এইটো 5th লাইনত আছে দেই It was mentioned in the said paragraph that as available from the Chita records of the said village and Moja, out of the total government land measuring 126.74 R recorded in the aforementioned new DAG numbers of old DAG number 687, no part of the land has been included in the periodic patta records in the name of the writ petition. It was also found during field inquiry that the petitioner had no possession of any portion of the land covered by the aforementioned new DAGs, which was created from old DAG number 687. Taking into account the stand of the respondent number 6, this court sought for instruction by an order dated 11/9/2023 as to whether there is any available government land in various new DAGs which came into existence in the recent resettlement operation pertaining to old DAG number 687. Today, Mr. B.J. Talukdar, the learned additional senior government advocate, have placed an instructions issued by the Circle Officer, Dispute Revenue Circle, dated 28/9/2023. From the said instruction, it reveals that a total of 126.74 R government land is still available. The said instruction is kept on record and marked with the letter X. Taking into account that the land has been allotted by the government and the petitioner had duly paid the premium as far back as on in the year 1994. The respondent authorities, more particularly the Deputy Commissioner, where? Guwahati, Kamrup, Metro, is under an obligation as per the settlement rules framed under the Assam Land and Revenue Regulation 1986 to issue the periodic lease in favor of the petitioner. Further to that, as the land still stands as 126.74 R of government land, still stands in the name of the government. Upon issuance of the periodic lease, the Deputy Commissioner, Kamrup Metro, or his delegate is also required to hand over the possession of the land in favor of the petitioner. In that view of the matter, the instant writ petition therefore stands disposed of with a direction to the Deputy Commissioner, Kamrup Metro, to issue the periodic lease in favor of the petitioner of an area of 1 Katha 10 lechas of land falling on any of the new DAG numbers which came into existence in the recent resettlement operation from DAG number 6787 part, and also hand over the possession of such land to the petitioner. The said exercise be completed within a period of 2 months from the date a certified copy of the instant order is served upon the Deputy Commissioner, Kamrup Metro. 93-94. It had no 93 and 94. So there are 3 premiums on 15/6. One is 15/6, then the second is in June 94, and the second is, the third is in December 94.
Nine to 11.
What about 9? Who is 9? 9 is what item number? Yes, what is your case? You are, who are you?
We are some landed person, madam, and government has also given us another land in our Puravatta, land which was given to us as coffee and marshy area, which is not fit for human habitation. So we made a prayer before the. Eight one thirty seven.
Page?
8,137.
Yes.
Yes, this is the real land, and we have come to know that, the land which we are, they have given allotment to some other person. And, we are receiving.
So you have been allotted a land which is there in the swamp area. Where is your allotment?
Episode 4, 55 pages.
Huh?
Page 55 to 130.
The below mentioned scheduled government land is given for you for possessing the same as per the condition mentioned in the next page. Here no right is given. You are only allowed to possess. Isn't it? Then
So, then my lord, I'm not people. Now, neither we can calculate now.
why?
Because we are complicated.
Where do you want? Guwahati. Where do you stay? Where are you a resident of what? Huh? No, village. So you will be only given land in the village Bhimpara as per your land list certificate. Is found not to have any land in the locality of village Bhimpara. And you have been allowed to possess land at Bhimpara. Then where do you want?
Well, actually, my lord, we were possessing land.
So you want the land where you are in possession. That is the land you want. But how much land? 1 kata 5 lakhs. Yes. Encroachers are okay, but if they are in possession of the lands, government lands, you allotting them some other lands and want to give these lands to somebody else, it cannot be done. You want that land for your purpose, it's okay. But to be given allotment to somebody else may not be proper. That is his entire case, isn't it? Affidavit, they filed yesterday, but that affidavit is not here. Huh? You have a copy? How many petitioners are here? Why they are only referring to one petitioner? Huh? You have around 29, 30 petitioners here. Huh? I think they are doing the right thing. They have referred to only one petitioner, taking into account that you must have paid the court fee of only one person. Huh? How much court fee? How much court fee you have paid? Court fee to go to say. You have paid the court fee of everybody? Rightly. So we will decide only on one petitioner. Which petitioner we are going to choose? Tell me. No, in this affidavit, if you see what they are saying, no land certificate issued in the name of any individual under Mankasa Revenue Circle, but a certificate having no land in the locality of Iman was issued in the name of the petitioner of the father of the petitioner. What do you mean by this? Paragraph 5 of your affidavit.
It says that no land in that particular area, Himapal. But the land policy.
No, the thing is, if they are in Burman land, have you filed applications for settlement? Huh? No, you are to file applications. Have you filed applications or not? Huh? Page 80, 86. 86.
Yes.
Yes. নিজৰ স্বত্ব দখল ভোগ কৰিব। স্বত্ব means what? Title? লিখিত স্বত্ব দখল। স্বত্ব দখল ভোগ। That second page is not there. Yes, why have you not enclosed the second page? That I was also thinking when I read it. So possessing the same as per the conditions to the next page. Huh? And secondly, have you filed application for allotment or not? Where? No. Why are you asking this court for passing orders unless you have brought on record those applications? Mr. I. Chaudhary, this is a case to be dismissed for non-enclosure of the document in full. Why have you not enclosed it? And have you applied after the 2019 application, land policy? No, because your entire case is on the land policy of 2019. Then, and you know, I would have understood that this matter has come all of a sudden from nowhere. This matter has been coming before this court every time on 23/8, then again on 18/9. Then why haven't you not enclosed the other conditions? Do you have a copy of that with conditions? Let us see the conditions. And the problem arises with so many petitioners filing it together. Everybody has their own rights. Learned counsels appearing on behalf of the parties submits that they have instructions to withdraw. 1777/2020 and 1778/2000. Have instructions to withdraw the writ petitions. Accordingly, the writ petition stands closed on withdrawal. Yes. Huh? What are the conditions? But these are not land allotment. But what type of documents are these? Yes, Mr. Talukdar, what type of documents are these? First, I have understood the land revenue regulation contemplates a lease or a grant. Now, it can't be a lease. Lease has every year, which is every year annual lease or a periodic lease. This is not so. It can't be a grant. And as such, he's not entitled to sell of the land also.
Yes,
He cannot sell.
cannot see.
He has to only possess, nobody else.
He has to possess, he has to use the.
But he can construct a house on that. Meaning thereby, the house becomes a part of the immovable property. How can you evict him later on with this notice? What type of documents are these? Because all these while I have never seen a document of this type.
Possibly, if emergency, some kind of emergency arose, then he will for some time.
Understood, but emergency also, if it is to be done, it has to be done as per law.
He has to go to the asset.
Then what type of these documents are these? These will create rights in their favor. Luckily, as of now, you cannot. These are not,
Because he is not in possession of that.
obviously he can't. He says that this is the swampy lands. So he can't. So his basic case is, look here, I am in possession of government lands. Why are you giving me in some other place? On the other hand, you are trying to give somebody else in my place. Why don't you want him to remain in his own?
I cannot say because they silent about that. But you-
And that was my specific instruction, Mr. Talukdar, on the last occasion, when the matter came up on 23/8/2023. This was the order. Mr. I. Chaudhary, the learned counsel appearing on behalf of the petitioner, submit that the petitioner have made specific allegations in the writ petition to the effect that though the petitioners have been allotted some other plots of land, but the plots of land wherein the petitioners are in possession, the revenue officials are taking steps to allot it to third parties. Taking into account the word, this court fixes the matter again on demand, the said affidavit be filed by the district commissioner so and so without fail. We don't, who has filed this? It is okay. But he is not,
He has not concern.
what type of affidavits are these? The affidavit which have been filed. No. Mr. I. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the affidavit which have been filed by the additional deputy commissioner pursuant to the order passed by this court on 23/8/2023 does not address the point as mentioned in the said order. Mr. Vijay Talukdar, the learned additional senior government advocate, also submits that an additional affidavit may be required to be filed, taking into account the order passed on 23/8/2023. For the sake of clarification, for the sake of convenience, this court finds it relevant to note down in the instant order that this court, after taking into account the specific contentions made by the petitioners, that they have been allotted, that the petitioners are in occupation of government lands, and they have been allotted lands in areas wherein it is not habitable, inhabitable. Whereas the lands belonging to the petitioners are in the process of being allotted to third parties. This aspect of the matter needs to be clarified by the district commissioner, South Salmara, or by his district commissioner. The learned council, this court further finds it relevant to note that although certain enclosures have enclosed certain land certificates, certain certificates relating to allotment of government land to landless people have been enclosed. But the said certificates do not, but the entire certificate had not been enclosed, meaning thereby the terms and conditions under which the land allotment has been made have not been enclosed. The learned counsel for the petitioners undertakes to file an additional affidavit bringing on record the complete certificates of allotment of government land in favor of the petitioners. It also transpires that there are 29 petitioners in the instant with petition, and however, the court fee of only one petitioner has been paid. The learned counsel for the petitioner submits that he undertakes to pay the deficit court fee on or before the next date. List the matter again on 22nd of November 2023. On the same date, the district commissioner, South Salmara, shall file the additional affidavit, and the petitioner shall do the needful as the learned counsel for the petitioner had undertaken to do.
And what will just whether point number 2, that is the character of IRB, then if you go back to the file there and the opposition. And for that we are trying to find the reflection. And the structure of the client.
So the interim order has not been extended. The legal counsel for the petitioner submits that an affidavit in opposition has been filed by the respondent number 2. The petitioner wishes to file an affidavit in reply and seeks for an accommodation. List the matter after 6 weeks. Yes. You filed affidavit?
Yes.
When? Oh, yes. What is the name of the petition? Zubair Aman. Lahore. The present petition has been filed by the petitioner seeking a direction from this court to the respondent authorities to provide personal security officer to the petitioner. Which party does he belong to? Indian National Congress. The petitioner herein claims that he is an active politician and is affiliated to the student wing of the Indian National Congress. The petitioner have also stated that he is currently holding the post of the Vice President of the National Students Union of India. It is the case of the petitioner that there had been various attacks on him by miscreants, and out of the same, in view of the same, there are serious concerns of his safety. For which the concerned authority was requested by the National General Secretary of the National Students Union of India to provide the petitioner with adequate security. The petitioner also submitted a letter to the commissioner of police Guwahati, thereby requesting him to consider the case of the petitioner for being provided with a personal security officer. As the respondent authorities have not done anything pursuant to the various requests made by the petitioner, the instant writ petition has been filed seeking the relief as already aforesaid. The record reveals that an affidavit in opposition was filed by the Commissioner of Police Guwahati, the Police City Guwahati, through the Deputy Commissioner of Police Crime Guwahati. In the said affidavit in opposition, it has been mentioned that a letter dated 1/1/2021 addressed to the respondent number 3, that is the Commissioner of Police Guwahati, was duly received in the office of the Commissioner of Police Guwahati. Thereupon, the Commissioner of Police Guwahati issued direction to examine the prayer of the petitioner regarding providing a personal security officer. Accordingly, a report was also called from the officer in charge of Dispur Police Station, wherein it was mentioned. Thereupon, the officer in charge of the Dispur Police Station had submitted a report stating inter alia that the petitioner is accused of criminal cases, and 3 cases by Dispur PS case number 3782/2019, case number 3236/2020, and case number 121/2021. which are pending investigation at the district police station. It was also mentioned that if a PSO is provided to a person who is having criminal background, he may misuse the PSO for unlawful or illegal activities, and thereby it further causes security threat. Taking into consideration that the respondent authorities have considered the request and based upon the inputs received from the respective police station, no steps have been taken for affording a personal security officer to the petitioner. This court finds no reason to interfere with such exercise of discretion by the respondent authorities. Under such circumstances, this court finds no merit in the instance petition, for which the same stands dismissed.
Okay.
14.
Yes, what is this? Who? You are who? Who are you? Directing the respondent not to continue the impugn action construction of wall over the land occupied by the organization of the petitioner. Who is making construction? Air Force. Air Force is making construction over your land without acquiring your land. There is a stay.
Your lordship, and I think it can be disclosed also, right? Remember, your lordship comes to page 35.
Yes.
Despite of lodging a complaint before the AGC, they have directly come to the High Court.
Yes, but the meeting was presided by the CS so and so. He asked the circle officer Iman to address the disputed land.
According
The
to the chairperson,
dispute is
is that
arising out of the land measuring 7 acres and 12 acres of CS Doug number 11 in Chora. If the total land of Doug number 18 is so and so and recorded in the chapter of MES. What is MES? Ministry of,
the airport,
you are there. Presently, the Defense Department has started construction of a Palka wall, which is currently under work. The representation of Navdeep Iman stated that the natives of the area have been organizing reviews and other cultural
it's
programs.
a military engineering service.
So they have strict objection against the defense. Oh, your land?
So,
Whose land is that?
open land. Demarcation of this particular area has not been.
No, whose land is that?
We have been taking up that particular land for the last 50 years.
No. Occupied by the organization of the petitioner. What organization? Huh? You are organizing. What do you do there? Navajyoti Yuva Sangha. Fantastic. And has the wall been made or not? It is still under construction from 2021. Why? There's no stay. Nothing is there. And who is your senior? Where is he? And where is Mr. D. Gogoi? Fantastic. Get hold of him at 2 o'clock. This is a fit case for dismissing. Where are you seeing? Huh? Page 21. 51. Oh, yes. Where is it? Established. Now, where are you? Means Roya, Tiniali, Jamuguri, Gaon. But they have no right. No. No complaint. Here the wall has already been completed. The security wall has been constructed and completed. Then, huh? That is there on affidavit. You have no right over the land, and what is all these things? Okay. We will dismiss it after some time. Have a more breather for another 15 minutes or have a proper lunch. See,
Number 2.
dismiss করেছে। withdraw করেছে।
22
হ্যাঁ?
22 করেছে instruction
এটা কি রেখে হলো?
22 পাওয়া যাবে
মানে কোনে মেনশন করতে 2 and 3 have been mentioned. withdraw হয়েছে 2 and 3. হ্যাঁ? 22 মানে এবার কি কারণ মারি যাবে যেহেতু মাতিব আপনাকে ভুল করার কারণে একটু হুকুম মারেন কোনটো ডিসপোজ হলো মানে উইথড্র করলেন yes
Around the time start is 25 minutes. There is an order of consumption of operation. The next one 11/8/2019. 11/8/2019. The fact of the case 25. These are the plans. For the
yes
then next month,
now what are you showing
next month,
this is for what do you want
I don't page 20, the order of
wait let us see what is your prayer not complying with the direction of this court contained in the order whereby respondent more particularly have been directed to decide on the proposal submitted by respondent number 2 in pursuance to the recommendation of the land advisory for settlement of land measuring demand. under so and so in favor of the petitioner and his wife within a period of 6 months. What type of land is this?
But pardon, then earlier it was an agricultural land, but as of now, there are not any agricultural.
Huh?
There is no agricultural.
Then
land used for residential purpose.
residential purpose where? Under Bordolini Moza, Kogamuk Living Circle, Dhemaji. It's in town.
Not in town.
So in village, how much land a person can get?
As further than earlier, like my God,
We are not concerned with earlier, now for the present.
2009, 3 bighas and half bighas for residential, 3 bighas for agriculture.
So you can get at best 3.5 bighas.
As of now, we go by the 2009.
Pass an order for settlement of human. But has the government approved?
Here's the direction.
Where?
For the idea of the mother, kindly come to this
Page?
29.
Yes. Then they have not taken any decision. Huh?
For taking up a decision as per the direction of the government.
Why did you wake up after in 18 and then have filed the writ petition in 21? Huh? What was it? actually? No, has the SDAC given the recommendation in your favor? Okay, thereafter, what did the deputy commissioner do? Then what did the respond number 1 do? Yes, respond number 1, madam, you are respond number 1. What did you do? Why instructions are required? Lecture? E, yes. Yes.
Page number 17, madam.
17.
Yes.
Yes, then name of illegal occupant. Foreign dollar. Yes, then he's in area of 8 bighas. Area under illegal possession is 5 bighas, 3 kotha 10 acres. How much land you have?
5 bighas, 3 kata, 10 lesser in that number 127.
No. Tell me how much land you have already. Rural?
In my name,
Why? You are in possession of 8 bighas.
it's a government land.
Area under illegal possession is 5 bighas, 3 kotha.
These 8 bighas, okay, this 8 bighas of land was reserved for a particular institution. Actually, they have taken 2 bighas of land. Rest of the 6 bighas was under my possession. So I have made an application for being reserved, and accordingly, if an order was passed, then my land
Then it will be de-reserved. Then
Then my lord, thereafter, immediately after de-reservation, this allotment order was passed.
the proposal for settlement of land sent by the circle officer is sanctioned by the IMAR through its proposal number so and so and is made in the name of so and so. Order shall be automatically cancelled if the land is not used for institution. So settlement is made in the name of Sri. Huh? What is this type of order? Page 26? 25, what is this order?
25 is the allocation order.
No, it is a settlement. Is made in the name of Horendolo? What is this thing? Allotment or settlement?
Then what is performed the allotment? Actually, 27 is the binding allotment.
Because it will be cancelled if you are not using it, meaning thereby the settlement has been granted to you. You are to use it within a particular period.
I am using.
Yeah.
No patta, nothing for. The only document I am for. What is patta? Yes, 27.
Yes,
27.
very difficult to read what is there. Yes, read it. Yeah, fine.
অনুমোদন জনাইছে।
No, how can the SDACA LAC do it? The Land Advisory Committee of so and so in its meeting dated through its proposal number 16 of so and so. So settlement is made. How can the additional deputy commissioner make a settlement in this manner? Can they? Without the government's approval? Then what allotment? Who can give an allotment? This can be at best be taken as a permission to be in occupation. Under Rule 16, nothing more than that.
Now, I think declared from the earlier order.
Earlier order, take your instructions. We are taking it at 2. Where? 3.
20.
The bonds referred to in B may be either negotiable and transferable. Now, this is if it is in the form of bonds.
No, madam, of course. Well, madam, that 20, section 20, subsection 2, clear 1%.
such probable
The
compensation
date of
shall be
vesting
paid
and
as when
communication.
each proprietor or tenure holder in case every year until such time as the compensation statement has been handed up. Under completion of the-
Where are you saying about the interest? Under which section?
Is there a matter that 2.5%?
No, that 2.5% is different. 2.5% of such probable compensation shall be paid in the interim to each proprietor or tenure holder in cash every year until such time as the compensation statement has been finally published. It doesn't say about the interest, because you see the in where
He said the book bought, but my love,
now the bond should be kept in such a manner that there is an accruing interest of 2.5%. But whether you are paid in by way of bond, because normally what happens if it is more than 12.5%, then in that case, the amount will be paid 12. In other cases, if it is more than 2,500, then in other cases, 12.5% of the amount shall be paid in cash and the balance shall be paid in cash or bond or partly in cash and bond. And in bond, when it is kept, it shall have accrued interest of 2.5%.
We may not section B, that in other cases, 12.5% of the amount shall be paid in cash and balance shall be paid in cash or bond. I don't know, I've got a latest decision of 22. In my reply, I have replied to this, we have taken two decisions. No, Dr. Candy. See, madam, and here also from the date of position, madam. There is. But 22, madam.
No. This is a case of falling under the Land Acquisition Act 1894. There it is categorically mentioned that their interest is liable to a, because the statute stipulates that interest is to be paid under 28 and 34. So that is there. And the issue involved in this case is as to whether the payment has to be from the date of taking over the possession or from the date of the award.
Yes.
So that we are not concerned.
From the position.
No, here you are entitled to others. Show me what are the decisions you are referring to. You have made reference to two judgments. One is of 2009, one SSC 618. Do you have a copy of it? Oh, you don't want the money. Then why should I take the trouble?
I could not make part of the hearing is because they are part to hearing it, then the file was there. But all my engineers, they have took so much, so I did not take out the file. The problem is going on for months together, my. For part two hearing is never done, then the part.
No. Nowadays, part two, no, madam, part two hearing lists are not being taken up.
Yes.
So what is happening is from part one, part two, it is being brought in part one. This is how it is being done now.
Yes.
So that part two hearing list, something happens. The issuance of a part two hearing list is only for an advance notice that these matters will be taken up.
July, August, this is the part two hearing.
It is still there. This matter is still there in the part two hearing list. And that is why it has come.
Along with other files, it was there. But now I don't know, they have missed this somewhere, so I did not find my file. Probably from them. So that is my lord, I did not make it. But I'm remembering that.
No, that is why I gave you an opportunity yesterday. Didn't I give you an opportunity yesterday and I have fixed the matter today? Then,
So looking for the file from the government, make it. If I today morning, I made photo from their file. It's another, whatever they have put it in the reply, that I will not take out. Your most early month, giving a time and it's after vacation.
no,
Whatever order you will.
when was the possession taken? Yes, anybody from here? When was the possession taken?
9 March 1963.
Huh?
9 March 1963.
Which were acquired by the government under the state notification of demand by demand. The extenure due to holders due to some person appointed the petitioner as the attorney holder for the smooth functioning of the compensation cases. That on inquiry in the office of the regulator, the compensation came to know that some cases they have produced in an exercise of the powers to declaring that some payments are specific self-stem transmitting with effect from first of April. The name of the petitioner for justice. The petition of the compensation of the page. Yes.
This is paragraph 9. Paragraph 9. Accepted the compensation amount under protest, and no interest and fee, along with the amount prescribed and delay in the gets in paying the compensation amount shall be issued. The announcement affects to increase the present directed to compensate the appeal by directing to pay interest for delayed payment. No particular is directed to pay compensation condition. Resolution be the payment is made. Is silent about the interest and there is no interest or payment of interest as a result. Otherwise, due to discriminant in the land acquisition under land acquisition act, they are getting interest and for this particular division act.
What do you do with section 5 of the Act of 1951?
Any provider or figure in the state or tenure in the state of this act shall be made with the state provided for in this act.
Have you paid the money to the original amount? 28 lakhs and all, they have got it.
Very much delayed, after 5 days they have paid.
Hmm?
After 5 days, after 7 days they have paid.
Now, was your possession taken over?
Yes, sir.
Where is it mentioned in your petition?
Optional expected they could not give money, but,
No, no, has the petitioner mentioned or anything in the writ petition? Their possession has been taken over.
data. No idea has come. After that, we got my learn.
Hmm?
It's a very old petition, no? New idea has come from the data position, from the order of the apex domain.
So how much interest you can be paid? Not 12, 2.5%.
6% should be there, so it's a long time, and that time, there's also more.
This is why 2.5% seems to be very reasonable.
6% might.
6% is too much unless you show something. Because you see, in the Supreme Court case pertaining to Aresh, like Ashok Kumar Mehta, that was a case where the bond or the national saving certificate, where the payment would have been made in cash as well as also in national saving certificates. These national saving certificates, bonds shall carry an interest of 5.5%, which have been mentioned. And therefore, the Supreme Court granted 5.5%.
Regarding pollution, madam, in excess the power concentration, land that some general specifications then transferred to and rest in the state from as they of Bharat. Also, April 1963.
That I have understood. Dim fit and proper. What is the dim fit and proper? Here what is there? When contrary to what it is here, the provision which was there in Karnataka is if the amount payable exceeds 2,000, here we have 2,500, the amount up to 2,000 shall be paid in cash and the balance shall be paid in non-transferable and non-negotiable bonds carrying interest at the rate of 5.5% per annum and of guaranteed face value maturing within a period of next 20 years. Provided the amount payable under the bonds of the clause may be paid in such number of installments not exceeding 20. So this is it. So therefore, the Supreme Court gave 5.5%. Now here is the case, it's 2.5%. So I'll give you 2.5%. I think that is
Because the long period of completion was.
2.5%. Following this judgment. Yes, what do you have to say? Okay, you can go now. Let me dictate. You are busy. The instant writ petition has been filed by the petitioner, claiming interest at the rate of 12% per annum on the compensation amount paid to the petitioner within a time frame. The facts involved in the instant case is that Sri Anwaruzaman, Sri Khairuzaman and Sri Kamruzaman the legal heirs of late Mohabbat Jaman Mandal and late Samastabhan Bewa and Nobi Jan Bewa. Where the jot holders of a plot of land measuring 49 bighas, 7 katha, 2 doors under Tozi number 4. The said 3 persons, namely Anwaruzaman, Khairuzaman and Kamaruzaman, page 10 had given a power of attorney to the petitioner, empowering him to take steps in respect to the compensation arising out of the acquisition of the rights under the provisions of under the provisions of acquisition of the lands of their lands under the provisions of the Assam State Acquisition of Jamindaries Act 1951, for short, the Act of 1951. From the perusal of the writ petition, it transpires that the government of Assam, had acquired by the notification dated 9/3/1963, the land belonging to the said three persons at measuring 43 bighas, 7 katha, 2 dues. On the basis of the said notification, the said lands to transferred and vested in the state, free from all encumbrances, with effect from the first day of Bohag 1370 BS, that is 15th of April 1963. It further reveals from the records, from a perusal of the writ petition, that a compensation officer was appointed under the Act of 1951 and in respect to the compensation, a case was registered being case number Roman 3-135/G/63 to determine the compensation payable to the tenure holders against the acquisition estate in terms with the provisions of the Act of 1951. The compensation officer Dhubri, by the letter dated 3/7/2010, issued to the Secretary to the Government of Assam Revenue Reforms Department, submitted the final statement of compensation and award of interim compensation for an amount of rupees 20,16,162 and for another amount of rupees 23,68,988 in respect to the compensation case number Roman 3-135/G/63, duly filled in Form C, award of ad interim compensation, and Form E for payment under Section 10-13 and under Section 20(2) of the Act of 1951. In spite of the said, compensation being adjudged by the compensation officer and the issuance of the communication dated 3/7/2010, there was no payment made to the petitioners, to the petition, for which the petitioner herein has approached this court by filing a writ petition, which was registered and numbered as WPC number 4063/2010. This court, by an order dated 26/7/2010, dispose of the writ petition directing the Principal Secretary to the Government of Assam Finance Department, Assam, to cause necessary steps to be taken to examine the matter in full, and in particular the tenability of the claim of the tenure holders to whom the present petitioner represents, and if on such scrutiny they are found entitled to the compensation as contemplated under the Act of 1951, the petitioner be the Principal Secretary to the Government of Assam Finance Department would ensure that the quantified amounts are defrayed without delay. It was further observed that as the tenure holders are waiting for long, the process indicated could be completed within a period of 2 months from the date of receipt of the certified copy of the order. It reveals, therefore, further, that the petitioner duly submitted the said copy of the order dated 26/7/2010, passed in WPC number 4063/2010 to the Principal Secretary to the Government of Assam Finance Department, as well as also the Finance Department. However, as there was no compliance to the said order, a contempt proceedings was initiated by the petitioner, being contempt case number 27/2011 before this court. Pursuant thereto, the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department issued 2 communications dated 23/5/2011 and 6/6/2011, whereby the sanction of the Governor of Assam was conveyed of an amount of rupees 20,16,162 and 23,68,988. Respectively. And it was further mentioned that the said amount be payable to the persons whom the petitioner herein represents as the attorney holder. It was also mentioned that the compensation amount may be paid on production of succession certificate in case where the actual claimant have died. It was mentioned that when the actual claimant are available and appeal for claiming compensation, the question of production would not arise. Be that as it may, it is the further case of the petitioner that the said amount of rupees 20,16,162 and rupees 23,68,988 were duly paid to the petitioner, to the principals of the petitioner. Taking into account that as far back as on 15th of April 1963, the rights over the land have already been acquired and stood vested upon the state. The petitioner filed an application before filed a representation before the compensation officer on 15/2/2012, seeking interest at a rate of 12% from the date of acquisition of the land. However, as the state representation was not considered, the petitioner has approached this court by filing the present writ petition. It reveals from the records that this court, by an order dated 18/12/2013, issued notice. And thereupon, by another order dated 19/11/2014, the instant writ petition was admitted. It further appears from the records that an affidavit in opposition was filed by the respondent number 3, that is, the compensation officer Dhubri. It was a specific stand as taken in the said affidavit in opposition that the question of payment of compensation at the rate of 12% or the payment of interest at the rate of 12% or any other interest, any other rate of interest does not arise, taking into account that the provisions of the Act of 1951 does not visualize payment of interest on delayed payment of compensation. It further appears that an affidavit in reply have been filed by the petitioner on 20/11/2014, wherein the contentions of the petitioner as stated in the petition was reiterated, and further it was mentioned that in similar matters, the Supreme Court had also directed payment of compensation, even though there was no provision in the Act for payment of directed payment of interest, even though in those relevant acts there was no provision for payment of interest. I've heard the learned counsels for the parties and have also perused the materials on report. From a perusal of the Act of 1951, it reveals that the said Act was enacted to provide for acquisition by the state of the interest of the proprietors and tenure holders and certain other interests in the permanently settled areas and certain other estates in the district of Gwalpara, Garo Hills, and Kachar. Section 3 of the Act of 1951 stipulates that the state government may from time to time by notification declare that the estate or tenure or proprietor or tenure holder specified in the notification shall stand transferred to and vest in the state free from all encumbrances. The consequences of the said notification has been stipulated in Section 4. Which provides that on the publication of the notification referred to in subsection 1 of Section 3 of the Act of 1951, all rights and interests of the proprietor or the tenure holder named in the said notification in the estate or the tenure, including his interests. Number 1, in the land with its subsoil and mines and minerals, Roman 2, in forests and fisheries, Roman 3, in huts, bazaars, and ferries, together with the rights to realize tolls from them, Roman 4, in any building or part of the building used primarily as office or kacheri for collection of rent, kacheri, C-U-T-C-H-E-R-R-Y, comma, bracket, of such state or tenure, bracket close, and number 5, his right to realize rent, royalty, cases, fees, and toll in respect of any such interest shall save and otherwise expressly provided in the Act of 1951. Shall vest absolutely in the state free from all encumbrances in accordance with the provisions of the Act of 1951, with effect from the first day of the agricultural year next following the date of publication of such notification. Taking into account the said provisions of Section 4, read with Section 3 of the Act of 1951, and applying the same to the facts of the instant case, it will be seen that with effect by virtue of the notification dated 9/6/1963, the tenure of the persons whom the petitioner, of the principals of the petitioner, in respect to the land measuring 49 bighas, 7 kathas, 2 doors and all, stood vested upon the state with effect from 15th of April 1964. A further perusal of the provisions of the Act shows that Section 5 makes it clear, of the Act of 1951 makes it clear, that no compensation would be paid to any proprietor or tenure holder whose estate or tenure vests in the state under the provisions of the Act of 1951, except as provided in the Act of 1951. The manner in which the compensation is to be fixed has been mentioned in Section 10, 13, 16, and 18. Of the Act of 1951. The manner in which the compensation would be payable have been mentioned in Section 20 and 21. In terms of Section 20, Section 20 of the Act of 1951 stipulates the concept of the payment of ad interim stipulates that as regards the ad interim payment of compensation, Section 21 is relevant for the purpose of the instant dispute, and more particularly, Section 21(2)(b). Section 21 is being relevant, and more particularly, Section 21(2) and more particularly, subsection 2 and subsection 3 of Section 21, for which the same is quoted here in below. 21 है ऊपर तो after a b to blank करेंगे b 2 to the 3 to the 4 and 5 dot. A perusal of the above quoted portion of Section 21 would show that after payment of the interim compensation, if the balance remaining is less than 2,500, if balance remaining is rupees 2,500 or less, the entire amount shall be paid in cash. However, in respect of other cases, 12.5% of the amount shall be paid in cash, and the balance shall be paid in cash or bonds, or partly in cash and partly in bonds. Subsection 3 of Section 21 stipulates that the said bonds would carry an interest at the rate of 2.5% per annum. In the backdrop of the above provisions, let this court take into consideration the judgment of the Supreme Court in the case of Aresh, ARESH, alias Ashok J. Mehta, bracket dead, by PROP.LRs versus Special Tahsildar Balgaum, BALGAUM, Karnataka, and another, reported in 2013 4 SCC 349. The same case, in the same case before the Supreme Court, the issue therein was similar to the issue arising in the instant writ petition. The question which arose for consideration before the Supreme Court in the said judgment, as regards payment of the interest on the delayed payment of compensation, taking into account that the Karnataka Land Reforms Act 1961 did not contain a provision for payment of interest on the amount paid. The Supreme Court while taking into account the provisions of Section 44, which was parameteria to Section 4 of the Act of 1954, Section 44 of the Karnataka Land Reforms Act 1961, which was parameteria to Section 4 of the Act of 1951 and Section 47 of the Karnataka Land Reforms Act 1961, which was parameter to Section 21 of the Act of 1951. No, Section 49, no, Section 50, 47, no, 50, which is parameter 51, which was parameter to the provisions of the Section 21 of the Act of 1951. Observed that the appellant therein was entitled to the interest at the rate of 5.5%. Taking into account that in Section 51 of the Karnataka Land Reforms Act 1961, which is parameter to Section 21 of the Act of 1951, stipulated that the bond amount shall carry interest at the rate of 5.5%. The Supreme Court further, taking into account the judgment, further taking into account the judgment in the case of Satinder Singh versus Umrao Singh, reported in AIR 1961 SC 908. Wherein it was observed that as the claimants have been deprived of the right to receive the income from the property And there is a time lag between the taking of possession by the state and the payment of compensation by it to the claimants. The claimants have a right to receive interest in the instant case. It is also seen that with effect from 15th April 1964, the principals of the petitioner have lost their rights over their tenure on the basis of the notification issued under Section 3(1) of the Act of 1951. The payment was made to the petitioners sometime in the year 2012, 11 or 12, sometime in the year 2011 or 12. During this entire period from 1964 till 2011 and 12, the petitioners have been deprived of enjoying their tenure and also the benefits which accrues on the basis of the tenure. Under such circumstances, this court is also of the opinion that the petitioner is entitled to interest from the date of vesting of the tenure upon the state, that is on 15th of April 1964 till the date of payment. Now the question arises as to what would be the quantum of interest to be paid? What would be the rate of interest at which the respondent authorities is required to be paid, required to pay to the petitioner? Applying the same principle as was laid down, was applied to by the Supreme Court in the case of Arish Supra. This court grants the petitioner interest at the rate of 2.5% on the compensation amount with effect from 15/4/1964 till the date of actual payment. No? No, he has written wrongly. You see the act. The act makes it clear. If I am not wrong, the act says it will vest when? With effect from the first day of agricultural year next following the date of publication of such notification. Meaning thereby the notification was issued on 9/6/1963. So the next agricultural year would be from the first day of the agricultural next following the date. Meaning thereby it will be on 15th of April 1964.
First of all.
Next. With the above, the said, this court further directs that as this is an old pending litigation, The respondent authorities shall make necessary calculation of the interest at the rate of 2.5% as directed, as stipulated, as directed herein above, on the amount of compensation during the period, and disburse the same to the petitioner, to the principals of the petitioner. And disburse the same to the principals of the petitioner. Within how much? What, 4 months? 60 days. 60 days from the date of submission of the certificate. Now, how long are you going to stretch this any further? Yes. Which one?
Half lot of occupying government and
Oh, that one. The Sangha. Huh? Yes. What case you have? They've already constructed the wall. What do you mean? You don't have any right. Okay. The learned counsel appearing on behalf of the petitioner, Mr. J. Abbas, admits that he has instructions to withdraw the instant petition. Taking into account the above, the instant petition stands closed on withdrawal. This one. Because here is a case where there is a direction passed by this court which has not been complied with. Because apart from that, Mr. Saikia, the case of, you don't have a case of allotment or settlement out here. Because what has been done, I don't understand. How did the deputy commissioner give it, additional deputy commissioner? On the basis of land area, can he do it? No, this is at best an allotment only for the purpose of allowing you to possess. That's all, nothing more than that. Until this is not cancelled, you cannot be evicted. That is it. This code, by an order dated 7/4/2010 in WPC number 1876/2010, had directed the Commissioner and Secretary to the Revenue Department to decide on the proposal submitted by the Deputy Commissioner Dhemaji for settlement of the land pursuant to the recommendation of the Land Advisory Committee within a period of 6 months. The petitioner thereupon had submitted the representation on the said order having not been complied with. The petitioner had submitted a representation on 4/5/2018. Thereupon, as there was no steps taken, the petitioner had been compelled to file the instant petition. Although notice was issued as far back as on 12/3/2021, the councils representing the Deputy Commissioner Dhemaji as well as the Revenue and Disaster Management Department has no instructions in the matter. Taking into account the above, this court fixes the matter again on 15th of November 2023. On that date, the learned counsels appearing on behalf of the Deputy Commissioner as well as the Revenue and Disaster Management Department of the Government of Assam shall ensure that the instructions in respect to the instant matter shall ensure that the instructions are there.
Item 16.
Yes, Mr. Chauhan, what is this? What notice is this? And there is a suit pending.
Sir, so that will be filed by the September 4. That will be with her. We can issue it for that will make it also.
And what is the circle officer doing? Who are you?
They are also-
I am the respondent for madam. We have filed a application.
So what? What is this circle officer doing?
So, well, no, this is partially allowed.
No, whatever, what is the circle officer doing?
So we have raised a complaint, but
So can you raise a complaint? You have won the case, go for execution. What is the circle officer's business to do? Who is appearing for the circle officer? What is this circle officer doing in respect to a private dispute between both of him? See page 42. See page 43, better off. या द्वारा अपना लोग को जन्म हुए फिर अपना भेदों पुलिस पूरी भेदों So what is this? The instant writ petition has been filed by the petitioner challenging
to point out one my application challenging it, but
what?
the earlier suit, they have raised about the earlier suit. It's all subsequent development.
Whatever may be, the circle officer has no business. Do you admit or not?
We have raised the complaint.
You may do whatever may, but can the circle officer interfere? It cannot. You do whatever it is. All will be subject to civil litigations will be do, and this setting aside of this shall not affect any of the rights as regards which is accrued under any of the judgments of passed by competency courts. The instant writ petition has been filed by the petitioner challenging the notice dated 24/2/2021 issued by the circle officer Nagaon Sadar Revenue Circle, Nagaon, thereby asking both the petitioner and the respondent number 4 to appear before him on 22/3/2021 on the question that the petitioner herein on the question that the alleging that the petitioners herein had encroached upon the land, upon the scheduled land. From a perusal of the writ petition, it reveals that the land described in the schedule to the said notice is the subject matter of our litigation. Initiated by the respondent number 4 against the petitioner and 5 others in title suit number 90/98. The said suit was disposed of by the judgment and decree dated 30/5/2005. Holding inter alia that the respondent number 4 has right, title, and interest over the scheduled land to the plaintiff, but the prayer for recovery of past possession was not allowed on the ground that the respondent number 4, who was the plaintiff, failed to establish that he was dispossessed by the defendants, that is the petitioner herein. It is also seen that an appeal was prepared by the respondent number 4 before the Court of the Civil Judge, Senior Division, Nagaon, which was registered and numbered as title appeal number 16/05. The said appeal was disposed of by a judgment and decree dated
28 of April 2000.
where do you get the date? Dated 28th of April 2006. Whereby the said appeal was dismissed. It is not known as to what transpired thereupon. Be that as it may, as it is a private dispute between the petitioner and the respondent number 4 and the revenue authority, that is the circle officer, could not have exercised any jurisdiction on the question of encroachment of land, which falls purely within the domain of the civil courts. This court sets aside the impugned notice dated 24/2/2021. It is made clear that the setting aside of the impugned notice dated 24/2/2021 shall not affect the rights of the parties, that is the petitioners and the respondent number 4, in any other proceedings pending between them before the appropriate civil courts.
In 17.
Yes, Midhu. for that one. Verify and pay. What type of orders I am passing out here? Verify and pay within 6 months.
In the present case is relating to the payment under the scheme of management program. Lions share has to be paid by the central government. Substantial amount has been paid already granted by the central government in terms of the order of the sale. That is why this is covered.
Huh?
That is why this case is covered by the judgment of the sale.
Show me that. Where is it? This one, 17/5/2017.
Yes.
Huh?
474.
No. This is different.
27,922 and common judgment.
Where is it?
WBC 474 2021.
No, are you admitting the amount?
In respect of the practice scheme, nothing to be specified. Because
No, because here the direction is to pay, no verification.
state has to give you money. State has already paid their share.
Some share has been paid by the state,
State part has already been paid,
only the central part.
central part.
Central part will be disbursed through you. Who is central?
No, here by the supplement is not required.
Then how do I pass an order then? A direction, how can it be given to the central government? If you want a similar direction, you make them a party. Because otherwise it will be difficult. You see, there is a direction. The Ministry of Jal Shakti to release them under the schemes. How can I direct them? You just make them a party. Other cases, which court? Huh? Very well. We'll place it before him. Let him pass. I am not going to pass without them. Because it will have a fight. Because you see, they will not comply. They say that we are not heard. How? Because the main direction is against the ministry. Here, who is representing you clearly says that we have no objections. Clearly says that we have paid our part. It is the central government who has to pay the 90%. 90%. And your amount is 73 lakhs. What do you want? The Learned Council, appearing on behalf of the petitioner as well as the Learned Council for the petitioner as well as the Learned Council appearing on behalf of as well as the Learned Additional Advocate General, Mr. B. Goswami, submits that the issue involved in the instant writ petition is covered by the judgment of the coordinate bench dated 27/9/2022, passed in WPC number 4734/2021. Upon perusal of the state judgment, it reveals that there is a direction upon the Ministry of Jal Shakti to release the amount under the scheme to the concerned department of the government of Assam. This direction cannot, in the opinion of this court, be made without in absence of the Ministry of Jal Shakti be made a party to the instant proceedings. Mr. S. Mukhtar, the learned counsel appearing on behalf of the petitioner, submits that he would file appropriate application to make the Union of India, represented by the Ministry of Shakti, Union of India, represented by the Commissioner, Ministry of, it shouldn't be Commissioner, it should be Secretary. Represented by the Secretary, Ministry of Jal Shakti, Department of Water Resources, River Development and Ganga Regeneration, New Delhi 110001 as a party to the instant proceedings. Because 3 weeks' time is granted for that purpose. List the matter. Otherwise, at the end of the day, you won't get, and you can't file a contempt. Hmm.
Here I am propose equity of our land for compensatory efforts in connection with lower property had to go. Here was yesterday they have filed an affidavit supporting our case.
They filed?
They have filed yesterday.
It is not on record. The Mahasau has filed. And what about you?
But they have supported our case.
Forest Department.
No one, Dimahasau.
And Forest Department has no role.
Otherwise, no, because the acquisition was done by the Dimahasau. They have given our land to the forest department. Now they are saying that they are ready to give another plot of land in lieu of our land. That is our, they are saying that.
They are giving.
Yes, sir.
We'll take it up when? Next week? To dispose it of. Kaliki, right? Oh, no, last week. This the matter tomorrow at 2 o'clock. The registry shall bring on record the affidavit so filed by the NC Autonomous Council on report.
Okay, okay.
We'll dispose it of then. Yes.
Our account has been seized by the FBI. And subsequently, an affidavit was filed by the FBI saying that it was on the direction of the police. And we have made the police a party for the, so that we went to the authority, FBI, they said that police have instructed them to freeze the account and on that ground they freeze. But before doing that, just one message was sent that your account is freeze, nothing more. Then therefore we came before the South. The FBI says that it is something why they have done it. Till now it is in freeze, nothing has happened.
Who is paying for the police?
Okay.
Mr. Manan, I have delivered one judgment in this regard, similar. This is done under 102 of the CRPC, if I am not wrong. Under what provision is the police direction?
Police has filed on it, saying that they had not done it, but because probably SP Kamrut Rail has been.
Because the account is in Bihar side. And I am a resident of that, possibly.
No, you have done freeze under whose instructions?
The instructors of the officer in charge, Bhangagad Police.
The Bhangagad police station.
It's not the, another police station will not be under SP.
It's okay, but you have done under the Bhangagad police station.
PS case is also mentioned. We have filed a PSK. Yes, yes, fine. Yes.
Understood. Yes, why have you made this superintendent of the police rural?
Because your lordship, when we went to the bank initially, when it was free, there even just one message in the mobile that your account has been free on the instruction of police. So we went to they said that it has been, they have not stated that it was Bhangagad police or something, nothing has. So since it is under the your lordship, I am from Bihar side.
And the Bayhata Sariani jurisdiction is under the rural. Therefore, we made the SP rural as a part.
Where is your bank account?
In the Bayhata Sariani.
Now you know.
Now I have.
So you need to
after the
implement. You file implement. Mr. Y.S. Manand, the Learned Council appearing on behalf of the petitioner subjects that taking into account the affidavit which have been filed by the State Bank of India, that it was upon the instructions of the officer in charge of Bhangagarh Police Station. He would like to file an appropriate application to implead the officer in charge of Bhangagarh Police Station as a respondent to the instant proceedings. 3 weeks' time is granted to do so. You also think of making the state, make the state also a party. Because once you being an officer of the state, without the state being a party, it becomes very difficult.
Initially, we were.
If you were making only the state bank, it is okay, but you can't just make the superintendent, because the superintendent, you have to first make the state has to be there.
Party event will also.
You can make anywhere.
All departments.
Yes, the home, I
All
think you have,
department, I think. If
and
you
there is
have
one-
stated that I make OC as a party. Lordship will also state that.
That you
Otherwise,
can
it
do.
will be difficult, they will not accept.
no problem, you can make it along with the submits that he will make the officer in charge of Bhangagarh Police Station along with the state of Assam represented by the Commissioner and Secretary, Home and Political Department as a party to the instant proceedings. For 3 weeks' time is granted. There's one judgment of mine in that case of what you call, I think it is delivered in the case of Mr. A.K. Bhuya, advocate. You may ask him. This is exactly on the question of freezing.
Anand,
Yes.
20.
Yes.
Sir, by an interim order. And this, the very first day when I moved this petition by law. An order was passed, the lordship will kindly have that.
Oh, dead stock. Dead stock.
Dead stock. So, well, there are two aspects. One is dead stock, non-consumable, and third is my lordship will declare under the Artswell bonded warehouse. Allowed that the taxable event was when the stock move out of the bonded warehouse. Now, it is not the case of the department that there was an, goods were removed from the warehouse, no tax was. So they are claiming and making a demand based on an executive order.
That 9(6).
Yes. That is my case. So also kindly come to paragraph 23, my lord, that is my case. Page 16.
There are many other litigations of similar time. Why don't you give the list, Mr. Gogoi? We can fix it up on one day and finish it up.
Yes, some of them are fixed on 9th. 9th of Mr. Roy appears.
Those two cases. And you have not filed affidavit in any of them.
No, one has been filed.
Another two matters were there, where there is also a huge demand which has been stayed. And no affidavit has been filed for 2 years by you.
One will get
Should
filed,
we repeat
another
the same order?
That will take care of it.
That the state excise department is not bothered with that amount and all these things which I have reported.
No, actually, they supported, they also, in fact, in my case, my lord, there is a proposal from the.
Yes, I know that.
Ah.
But the problem arises out here, Mr. Chaudhary. You see, the main problem is the VAT.
Yes.
Don't you think the finance and taxation is an important part? Because the money goes from there. Because what happened, if I recollect, while taking up those matters, there was a proposal given by the Commissioner of Excise saying that kindly don't ask them any amount as regards the VAT and all. The state government said that look here, during COVID, we are facing a lot of problems, and as such, we are not going to do it. And as such, they have to pay. And it is on the basis of that the excise is doing it. Excise Otherwise, have all the sympathy with you, and for which he is not filing the affidavit.
But in our case, initially the demand was 19 crore. Now it came down to 1 crore. That too because my service stock were not taken note of. Subsequently, there is a report that those vessels are all also examined by them, not by us. And they have found that this is not possible. Since the goods did not, it's a loss to us. There was some two partners died, that's why this happened. The whole thing is a huge loss for the minister.
No, because that has not yet been done. One judgment which I passed on this, there was a proposal wherein they have been asking for the destroying of the dead stock.
Yes, my lord.
What has happened there? That judgment pursuant to that.
I cannot recall
And you are
it.
still waiting.
As part of that appeal.
Yes.
I has taken up.
So that is one thing where they have done. There is another judgment. There are three judgments. One was appeared by Mr. I. Chaudhary, and the other one was appeared by Mr. Pranbora. But in both, NJ Khatonia is the common factor. And that matter is also, Mr. NJ Khatonia was there, where Mr. R.R. Gogoi was appeared, and he has not filed in same matters.
Same.
Let us fix it on this on. You file your affidavit when?
Nothing is coming. We are just.
No, but Mr. Chaudhary, there is one big problem which you are facing if this court takes up. Without making the finance and taxation, you have made the finance department.
I am not pay that on.
We are only concerned with the VAT. This is the VAT is the main problem.
No, but I know, but question is my lord, I will be liable to pay back only if I am liable to pay excise. Both can't be I must sell it, then only my taxable event comes. Here in this case, it is not the case of the excise authority that I have sold or cleared from my warehouse and have not paid it. They say on the dead stock I am liable to, that is the.
No, because in view of that executive order, what has happened is, they say that all these things will be measured, and you have all acted upon that. And thereupon, there was, I think, clause 3 or 4, it said that the commissioner will then fix up the whatever amount, and then they will make the payment to that effect. Now, this is the dead stock amount which was there. Now, it includes the VAT amount, and VAT amount, we are concerned here with the VAT also.
That will be chargeable only when there is a sale. There is no sale. The stocks are lying there. In my case, there is no clearance.
No, understood, but
Yes.
are you not challenging the
I am challenging
order
his order. eventually
wherein they are also asking the VAT?
Yes, part of it is VAT. That
VAT?
is there. If a lordship kindly comes.
So
to
if it
say-
is the VAT, why you are making the finance department?
No, my
party?
lord, finance department has not raised any, office of the commissioner of tax or superintendent of tax has not raised any demand. The demand has been raised by the excise.
Understood, but it has where would the amount go? If you don't make the finance and taxation department, you have made the finance department. Finance department has no business out there.
No, my lord. The demand is not by the jurisdictional superintendent of tax or by the, my lord, commissioner office. That's why we have not made them the part. My lord, in the case of
But
excise.
can this court say
No,
that the
it
VAT?
operates to the commissioner excise. The money will go to the commissioner excise, they will approve it. Normally they will not. If I am liable to pay eventually, the lordship, then I will have to pay to the commissioner of excise department and they will pay.
See, this is the question of the point of collection.
Yes.
Point of collection may be with the rate, with the excise.
Yeah.
But the loss would be incurred by the finance.
Especially the loss will be of the government of Assam. If at all lordship eventually holds that we are liable to pay, and we have a liable to pay to the government of, it will go to the same, my lord, treasury of government of Assam.
But don't you think that without the finance and
Since-
taxation?
Since my lord, no demand was raised, that's.
No,
why-
because it is the point of entry is point of collection is them, so they will make the
No
demand.
connection. We have got as a licensee, as a bonded warehouse licensee, my lord, we have no connection with the superintendent of tax. Our entire liability is operates to the excise department.
You see, this order of 29th of August 2016
Yes.
categorically shows this
But
is,
then it shows, my lord, no, please come to page 42.
you see, no, page, kindly come to page 55.
Yes.
It comprises of whom? The head of the joint team shall then furnish a report to the Excise Commissioner and the
Page
Commissioner of
55, my lord.
page 55, clause 2.
The head of the joint team shall then furnish a report to the excise commissioner and commissioner of tax, which is the working day of Assam excise rules coming into force. A warehouse list containing brand wise and yes.
So everywhere you see,
My-
for the purpose of question of the VAT, which is the question,
Yes.
the Commissioner of Tax is rolled out here as per this order.
In fact, I am making a challenge to this notification. I am saying, my lord, by an executive order, I cannot be a person with liability retrospective. Roughly, can you see, this came on 29/8/2016.
Hmm.
And my demand pertains to my lord period prior to 2015. And my license was cancelled, my whole thing was closed in July 2015 prior to that.
So therefore, no, so therefore, after this, you did not remain a bonded warehouse.
No. I didn't remain. It means so things should have been different. Prospectively.
So for you, this does not apply.
Exactly, that's all.
That is his point. The big distinction is there.
I'm not an ongoing
this-
concern. Had I been an ongoing concern, then what's this?
The other matters, my lord, they're still running. This is closed.
Long back, my lord. Two of the partners died, my lord, that's why they could not carry on.
So what is your case here?
My case is, my lord, the commissioner office itself has written to the government
Hmm.
that the stock should be allowed to be destroyed and my lord, my demand should be.
Hmm.
That is my case. Government also knows it, my lord, but somehow they are sitting over it. They wanted some orders to come from the honorable court. Initial demand was 19 crore, then it came down to 1.60 crore. Then that also, my lord, now the subsequent report says, while raising the demand of 1.61 crore, a part of the thing were not medically examined. Subsequently, those were examined, they had said total loss.
Here, you see, we are concerned with this document at page 51.
Once. Yes,
Are we going,
Yes.
you are challenging this?
yes.
Now, why then it is written that in the erstwhile month bonded warehouse, now wholesale warehouse license?
No, my lord, what has happened, I think at some point of time, this bonded warehouse made.
Understood, but you were closed prior to
My
that.
lord,
So under such circumstances,
the
this,
report itself will say, my lord. I'll come to that.
so it cannot now be the wholesale warehouse.
Can't be.
It then, wouldn't that the entire thing be wrong?
Yes,
The entire edifice of this
Yes,
order is wrong. Taking into account that you have done it in the same type like others, where it says that the erstwhile bonded warehouse, now wholesale warehouse. Because that order of the governor will only apply in respect of a transition.
yes.
But here they have closed in 2015.
Exactly. That was-
What exactly? Then why have you issued?
Since finance was involved, madam, part of the finance, so I was listening at that point. Otherwise, madam, this test is very clear whether this structure has a retrospective effect or prospective.
So here, his case is simple, saying that when there is no sale, I was all along a bonded warehouse earlier, where at that point of time, keeping the stock did not entail payment of tax or excise duty. It required only later on, after the 2016 Act, that the 2016 notification, that it was required that the bonded warehouse, unless they have a manufacturer along with them, would become a wholesale warehouse. And for which they are required now to have paid stocks with them. So the sales tax and the excise duty has to be paid if you are keeping it in, because you now become a wholesale. Now, when he does not become a wholesale account, where is the question of issuing this?
Demand.
But then also, Mr. Chaudhary, make the finance.
I can do that.
Because you see, otherwise it won't be proper. Let us, because this is the same, yours, therefore your case is, first I did not pay excise for that. And when there is a no sale, where is the question of that?
And that's my case in para 23.
So if that is your case, but without the finance,
I have made the point.
don't make the Mr. Borbuzari here,
Ah.
you bring Mr. B. Gogoi. That is why Mr. Borbuzari is not here to represent, although it is response number 2 is the finance department.
Principal Secretary Finance is a party.
That is what the finance department is not the finance and taxation.
Okay, I'll make finance and taxation a party.
You make them, and this is the small point, we can finish it off.
Yes, sir. All right.
The learned senior counsel, Mr. Kane Chaudhary, submits that he would require an accommodation for filing an appropriate application to impede the finance and taxation department of the government of Assam as a party, taking into account that the impugned notice contains an imposition, an unwarranted imposition for excise duty, excise, state excise, as well as VAT. 3 weeks time is granted. Should I fix a date?
After vacation.
I can.
Or my lord, after Diwali. So that Supreme Court case will continue. After Diwali.
We will, you file that
Okay,
application.
first let me file.
You file it.
Yes, sir.
Thank you, and Lordship, I am paying for some more time of getting instructions.
What instruction? Demarcation?
Yes, Lord.
It's a simple case of demarcation.
Whether that was done or not, Lordship,
Okay.
that is
The petitioner herein is aggrieved by the inaction of the part of the respondent authorities in not demarcating the land. Huh? You are challenging some notification. Huh? Impugn notification, whereby another 15 have been included in Mazali Manunguri Sapuri.
That is another aspect. That is one of the aspects.
You are challenging this. I think if that is so, you need to file your affidavit. This court by an order dated, this court by an order dated 15/7/2021 had issued notice however, till date, no affidavit or instructions have been received from the responding authorities. Taking into account the above, list this matter on 4th of December 2023. The affidavit be filed by the contesting respondents by 24th of November 2023. The petitioner would be at liberty to file the reply if so advised. Huh? It is already there.
Item 23. Some of the tender has already expired. Some of the tender has already been expired.
Infractions.
There's the interim order also.
Infractions. What tender?
Tender will put the question of, put in,
And by taking an interim order, you have rendered it infractions.
there's the order of the tender.
Also inclined to grant the liberty to be apply for inter-district travel to Sweden. Having regard to the grievance, it would not be possible for the person to obtain certificates for other than being a resident of and taking into account any month or so of the implementing state, there is one still in next state. And it has been continuing.
No, my lord, no, there is a call for my lord and my lord,
What was the tender for? Let us see.
tender, it is, if tender is at 30 days. So my lord, my lord, and it's a right from my lord. Yes, my lord. How much is it?
Oh, 2021-22. The instant writ petition was filed challenging the e-tender dated 5/6/2021 for selection / appointment of handling and transport contractors for transportation of food grains under NFSA 2013 of Morigaon district. It appeared from the very tender that the period of the work was from 2021-22. This code, by an order dated 21/6/2021, had stated the e-tender dated 5/6/2021. The interim order thereupon have been continued from time to time. In the meantime, as the period of the work, as mentioned in the e-tender, is over, nothing survives in the instant writ petition, for which the instant writ petition stands closed as infructuous. The respondent authorities would be at liberty to take appropriate steps for selection, appointment of handling and transport contractors for transportation of food grains under the NFSA 2013 of Morigaon district as permissible under law. Interim order stands vacated.
24.
What? Who died?
On that, father,
Son died?
28,
When did he die? 16. We dispose of. How much? 5 lakhs, 3 lakhs, 2 lakhs? Accident? How? Where? Which vehicle? Boat? Huh? Vehicle is what? What vehicle? You have got the insurance. Insurance you have not got. No knowledge. State government has no money to pay to many people, and now you have. Okay. So dispose. Verify and pay. 3 months.
25. Was a matter of party that real love is the son of the
Who died?
son of the
Road accident,
yes,
traffic accident.
Yes.
Where?
127
How?
when the son of the petitioner was sitting on foot from village Rampur at that time on with the son of the
Disposed. 3 months.
it's, those are, this to carve out, an area from my, section, my not as a system marriage instruction, but without any effort, but of the government order, at least 9.
What are you challenging?
My lord, a recommendation of my lord, a letter from the Inspector General of Administration, my lord, to the district registrar, who is the DC, my lord, for appointment of a Muslim marriage registrar for one particular area in North Kolkata. My lord, and secondly is a frequent advertisement, my lord, by which advertisement or by which applications are involved with the practice. But here the authority is to give the government, my lord, to market areas, my lord, other than takes up the marriage restriction. On section 3 and section 5 or rule 5 of the rule,
They have filed an affidavit.
one of the state government has supported my case.
Then who is opposing?
What shape I am carrying on behalf of respondent number 8.
Who is it?
We have filed in, individual applications also.
You have filed
And individual applications.
for what?
For the individual.
What interim is there?
What's, the selection was first state of the by order dated 10/9/2020.
Oh, where is that? I is there. Okay. Taking into account that there is an interlocutory application filed for vacating of the interim order dated 10/9/2021. List the matter in the column of stay vacating on,
My lord, there is an order dated 7/10/2021
what is that?
in the IA saying that the petition will be taken up for this.
Taken up on 12th of October, be listed on here in the stay vacating column. Don't worry, if it comes, that is the item number 1, it is going to finish on that.
I have that file.
Leave there.
37.
Sorry, my lord. Order.
The interim order partially. No, there is a direction to continue. Let it be there. Is not- Yes, what is this? 30 lakhs APDCL.
My lord, it is better teacher name was about it, but currently the answer is. I don't like that.
Who is to appear?
It's all.
Where is he?
Currently the answer is.
Electricity report is there. So, your responsibility. Why tomorrow? He's only going to get 4 lakhs. Then there is only one council, APDCL. Is this the state of affairs? They are taking money right, left, and center from everybody, and they don't have money for having 4, 5 councils. Huh? What is this? What is this appearance? Do they have the vested right to appear in one matter? What is that simple? Have you challenged the electrical accident report? The last order, which was passed on 23/6/2023, submitted that he has received a copy of the electrical accident and prayed for 3 weeks to go through the same and to respond by way of a counter affidavit. And no counter affidavit then. Yeah? List the matter again. We impose interest next time with you. List the matter on. November 17th, on which date an attempt shall be made to dispose of the petition.
28.
What is the challenge? You have got it. You're running it. Okay, let him run during the most day. Allotment the petrol pump, my IOC. What is your ground? Group 1, group 2, group 3. He has been in group 1. You are also in group 1. You say his land is not properly given. He doesn't have an ownership over the land. Neither there is a 19 years, 11 months lease. Then why was he considered in group 1?
That is the reason.
So the matter boils down to only that. Why do you need to file an affidavit? The only thing is that you, Mr. Roy, you are appearing for? Yes. Oh, why did you put him in group 1? You have no instructions. All is happening because there is no stay. We do one thing, Mr. Roy, we stay. We stay, then the things will move. When a notice has been issued, when Mr. Roy, you have appeared on the last occasion. But last occasion you were appearing on behalf of the central government. Now you are appearing on behalf of respondent 2 and 3. How is it possible? Yeah, the lawyers change like this. Yeah, it seems to be the collusion. Huh? So, is this the state of affairs? Because all along appearing for the central government, today is appearing for SPC. Yes, tell me. Now you are appearing. There is change of counsel. Why? Why did you put Mr. Payang in group 1? He didn't have a ownership land.
The land documents.
Ah. Yes. Offer belongs to Bipul Mill, the candidate himself, and your claim that the candidate had offered land belonging to their brother is law is not correct. Then what remains? Where is your application, Mr. Pang? You need to show me only 2 things. You are what is your name? Huh? Vipul Milli, and you are Pramod Milli.
Yes. I am Jugen Milli.
Okay, you are Jugen Milli. Okay. Wait. Jugen Milli. Okay. And do you have an application? You have his application. And what is his document he has given to me?
Yes, given the land of others. And there was the respondent has written that the people maybe the candidate himself that land offered whether belongs to people maybe the candidate himself. There was this like
Ah. See, how is it? How are you saying that? What? No. This is on the basis of there is no registered lease deed out there. Are you willing to transfer the land on sale long-term bill? Yes. If yes, here in your application, his application, he himself says that the land belongs to one Pradeep Pagag. And relationship is son-in-law. Oh, his application you are going to file. This is his application. He says on the copy of the ER, there is no registration, nothing. Then he has to give it in a lecture in a particular format. And the affidavit in annexure Roman 3A. Then what is this type of cases?
The respondent has lost it. He didn't sit there, but,
No, I think this is the fit case for stay. During the winter, there should not be any running of this petrol pump. This is the manner you have done it.
And that lordship, the relationship here. is
No, it's
so-
son-in-law.
Not son, because I am from the same locality. He is the brother-in-law. He is wrongly mentioned as son-in-law.
Yeah.
Now, the person's lordship, I have given the.
No, maybe. And does he come within the ambit of the family?
No lordship.
And if he comes under, he has to give that. Has he given that affidavit in the format 3A? No. Wouldn't have. Chalo. This is the matter to on today, on 5th at the top of the list.
Lordship, may kindly be directed to audit the record.
Mr. S. Thakur appearing on behalf of HPCL shall produce the records on that date. 6th, at top of the list. Give it back to him. Not on record. Affidavit in opposition, affidavit in reply. What is this type of matter? Oh, that is demolishing. Nagaon. Huh? Okay. Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner submits that the Nagaon Municipal Court had filed an affidavit in opposition in the matter for which he would like to file the reply. List the matter again on 10th of 10th of November. 20. Okay, 2011-2023. The affidavit in reply be filed by 16th of November 2023. The interim order postally shall continue till then. Any instructions, madam?
I'm hearing the second case. And record has been converted to-
Reply shall not be issued directing email to submit a report today about the progress made towards the disposal of the application number IMAN dated which is presently pending. Now, whether it is still pending?
That instruction I will. That instruction I will. When we do this.
The instant repetition has been filed by the petitioner, being agreed by the delay in disposal of certain applications by the who? By the circle officer. By the circle officer, Dispute Revenue Circle, being application number 1908 dated 14/9/2020. And the application number 4060 dated 13/9/2021. Today, when the matter has been taken up, Ms. M. Burman, the junior government advocate, have placed an instruction issued by the circle officer, Dispute Revenue Circle, wherein it has been mentioned that appropriate steps have been taken for the purpose of disposal of the said applications. The said instruction is kept on record and marked with the letter X, taking into account that the matter is presently pending before the circle officer, Dispur Revenue Circle. It would not be proper. It is the opinion of this court that it would not be proper on the part of this court to continue to monitor the said. Be that as it may, this court therefore, however, directs the circle officer, Dispur Revenue Circle, to dispose of the said applications as early as possible and preferably within a period of 3 months from today.
As well as ADC revenue.
Full stop. Further to that, the ADC revenue of Kamrup Metro is also directed to ensure that the directions passed herein are duly complied. A copy of the order being given to furnished to Ms. M. Borman for due compliance.
Okay.
Yes, Mr. Bhatti.
I don't interpret that 148 so-called
You are challenging a so-called notice. 148. Reassessment.
no business are clear.
Huh? On the question of jurisdiction.
Yes, I know that it is no more than integral. In view of the separate movement,
No, that I know. Starting from Calcutta discount.
that is
What is it? No, you can challenge it. There's no quarrel with that. Starting from that is why I'm saying from Calcutta discount was the first judgment on that point by the Supreme Court. Here they must have relied on Calcutta discount. Anyways. Now. You are on the ground that the reasons to believe. Not satisfied. Affidavit in opposition. Stay. Matter has been pending. So we need it to take it for final disposal. When? Taking into account the pleadings are complete. And there being a stay order. There's an order of stay to the proceedings so initiated under section 148 of the Income Tax Act 1961. And an urgency being shown by the standing counsel of the Income Tax Department. This court fixes the matter for final disposal at the admission stage on 21st of November 2023. Even admissions. Even admission gain even. Yes. Appears that it agree by the inaction and not taking steps to certain representations being submitted and instruction have approved this court. Pending approval.
the petition, my lord, he filed in the form of PIL, my lordship, he filed his paragraph 1, my lord. He is a NGO, he is an unregistered NGO, my lord. How come he can file a writ petition, my lord? Representing a private person? Me. If it is unregistered, my lord.
Who are you?
I am the private husband number 4. My rival, my lord, they have collected some document, my lord.
They have challenged what?
They have challenged, my lord. I have occupied some government land, my lord, some part, my lord, and I am staying there.
They filed a writ petition, my lord. They have collected the document from my rival, my lord, who was also lost in the election, my lord. I had also contested the election.
You? How can you contest?
My lord, I had contested election. The document,
Nagarik Suraksha Mansa is contesting
No, no.
election.
Nagarik says that the writ petitioner, my.
Oh, you are?
I am the private assault number.
Okay.
My grievance is that, my lord, this time,
You lost the election.
I lost the election and they have collected documents from there, my. Then, my lord, in the form of PIL, they find this. Oh, it is not registered. It's a
No,
form of-
they are asking for disposal of the representation.
But even though, my lord, my eligibility of the writ petition is there.
You don't have to first send anything, but again, right there.
Huh?
Who is
He, oh, if we accept that he, occupying government. But how he's the right direction? That is not clear. Para nine.
How?
Para nine, page 7. I understand.
Para 9, the last penultimate paragraph. No, yes. They allow the respondent number 4 to occupy government and construction of the right to life and personal liberty, and also right to have healthy and what? Too much. Luckily, I didn't read it loudly. Other people may laugh. Huh? What? Who are you? NGO. Nagarik Suraksha Mansa. And Nagarik Suraksha Mansa's right to life will be affected and personal liberty. My goodness. Huh? File an FIR. If there is any problem with all these things, file an FIR. But what is all this thing? No. It's too much. My goodness. You must be doing very well, I see. Otherwise, why would you have approached the High Court? You are well to do. We impose a cost. What do you mean? 15,000. Yeah. I kept it open, I suppose. Where? Hmm. Chalo. What to do? Dismiss. Withdraw. The learned counsel for the petitioner submits that he would not like to press the instant writ petition. However, he submits that the withdrawal of the instant writ petition should not preclude the petitioner to avail other remedies available under law. Taking into account the above, the instant writ petition stands dismissed on withdrawal. It is, however, made clear that the withdrawal of the instant writ petition shall not affect the petitioner if to pursue any other remedies as permissible. Yes, madam.
Yes, if you approach the similar, we should not pay your own. You give the best to decide whether the report is not as release the petitioner or not.
For set aside and quash the impugn order by which the respondent number 5 had terminated the petitioner from his mining permits and forfeit the bid security and debarred him from participating in any tender process.
There will be the department has also removed.
Now he wants the bid security.
He wants a bid security and the others will return to the.
You are not going to return.
Then for that, he has approached the signal on
Huh?
the BCM. The BCM, the authority will decide the bid security because there is a provision for appeal also.
So what? Now she is before us. After 2 years, should we now relegate, will go there? This court should have done on that very day, before issuance of notice by this court, who issued this notice? So, I only issued notice in 2021. Health and environment wherein the resolution of the point that the proposed manual is aligned with the outer economy and the student society to the business and it is available before me. I think it would be fully reflect this in this state till the return date. Accordingly, the petitioner is advised to participate in the tender initiative. Oh, I stayed the blacklisting, and that is why you are doing it. Okay. So they didn't do anything. No. I think we need to take it. We will take it on the next day after vacation. Enjoy your pujas. This is the matter of the vacation on 29th of November. In the meantime, the respondent forest department shall file the application by 21st of November. No? Affidavit filed. What is this matter? Affidavit is filed, then what happened? What is he asking?
They are basically asking ultimately kindly come to please satisfy with the institution. They are good, sir.
Residential status, protected class status of the community of the petitioner or the people of Ahom Gorkha belonging to Sodia Belt and so and so.
Where in the affidavit in the written,
I think when the pleadings are complete, it seems to be contested. Contesting matter.
From 1947,
Hmm.
the new department issued notifications. Thereby might have demarcating certain areas of land within the Sadia tribal belt. And specifying the.
We'll have it on 14th of December. So the taking into account that the pleadings are complete, this is the matter on 14th of December at the admission stage for final. Look at us. Yes, Mr. Vardhari, any instruction as for conversion of the annual pattas of the. They are still enjoying the annual pattas. Yeah.
They are seeking conversion of their land from Gabriel Patta to Biani Patta. In proper format. So under that circumstances, the Bible could directed us seek instruction as to the state of their application. Particular basic some instructions that he was in the form of an application.
What is that instruction?
Because here it is the deputy commissioner who will have to take the form because he is the authority.
But as per your land policy now, this conversion should be permitted, isn't it? You understand? Okay. Mr. J. Hendik, appearing on behalf of the Deputy Commissioner Nagaon, submits that he has received the instructions and would like to file an affidavit in that regard. Please the matter again on 15th of November 2023. The affidavit be filed by 8th of November 2023.
land was restored by the national higher authority. Compensation calculated 3,77,129. Fundamental other person can claim the compensation. And we say that matter on the inquiry was made by the circle officer. Kindly release the case 30.
What are you aggrieved with?
Not but compensation. And this is the case 30 last.
Is there any dispute?
Okay.
Who are you?
And for any savings, one.
Is there any dispute?
There is a dispute in the private respondent and in the
Who is the private respondent? No, private respondent is not here.
Okay.
There is no private respondent here. Who are you?
any savings.
This is what? The private respondent is not here.
Private respondent is not here, but only
Here you have stated out there, both Srimati Rupali Rabha and Kamakhya Prasad Rabha refused to share and claim the compensation amount in whole. So you are having a dispute. Then who there?
No, that's not that. After that, there was a hearing.
First of all, why haven't you made that person a party? Without making him a party, how can this court adjudicate? Tell me. Your case should be dismissed on that ground. A dispute is between you and A and B, and you are dragging all the other people, but not B.
Possessed by the petitioner, not by the other party. That is cleared by the circle officer.
Possession is not the only thing. You have the ownership. You have the ownership over the land.
Government land. Government land.
And what are you getting? Zirat. And the house belongs to whom?
Me.
And why is Kamakhya Prasad Rabha claiming it?
I don't know, my lord. That's why.
So, if that is a dispute, can this court decide? No, unless you make him or go there. Huh? How can that officer decide? Mr. Counsel, have you gone through the Act of 1956?
I agree, my lord.
You agree? Then what are you doing all these things? What to do? Huh? You file an application for impleadment. Or the other way out is you go and file an application for sending it under 3H4. See the provision of section 3H4 and 3H5. This can only be decided by the district judge. Think about it. Over Puja. Then we take it. List the matter of Puja. Yes. Shall obtain instruction as to where. Oh, that one. That new 2020 mod. On 2013, he was not entitled to. He had a problem. As to whether it would affect or not, that is another thing, but there was a problem and it was referred to the high authorities in 2013 itself. And you are appearing for? Who are you? Fantastic. And IOCL, is IOCL still interested in that particular property? Yes. Because that is what, because from 2013, you have not taken anything. Your high authorities are silent. So they are closing that advertisement. They're not interested because that plot, they are saying that we don't want to go ahead with. This is what it is being mentioned. I think Mr. Council, file a short affidavit on this point. A short affidavit. Then I think it would be better instead of going by this mail. Huh? Then we need not go into all other discussions. Because you can now, as per that scheme, you did not meet the criteria. Then you proposed an alternate land. Now this alternate land is outside the scope jurisdiction. So that cannot be.
Initial offer of land, madam, as per the new guideline. There's no violation.
Understood, but they are not going to go by that. Now they don't want to go ahead with that. I do one thing, I do give it out there, and thereupon, here is a case where did you meet any of the criteria? Did you, where you put on the group 1 or group 2 or what? Nothing.
Category of women, for the purpose of providing employment to women. Especially it is as the highest mark. That is what we want to speak. After that, my lord, after the selection was published, my lord, they did nothing. And they did not offer anyone else on that plot of land. Very specific, 24 and 28 number school. On that particular place, only I have land. And I secured the highest marks. Even after the evaluation report was given by them, even thereafter, that was in the month of April. My interview was conducted in the month of May, subsequent month. And I was the highest secured marks.
But can you enforce upon them that you have to give me, if they don't want to pursue with that advertisement any further? Do you have an accrued right? If you don't, they may say, no, we don't want it now. The only thing which this court can do is let them file the affidavit. This court will close it, giving them the liberty to proceed to go for any again fresh tender. And I'll also reflect that as per the new guidelines, your land is proper. I think that observation may this way or that way may help. Okay, Mr. Your name? Deborah, appearing on behalf of the respondent number 2 and 3, submits that he has received certain instructions which he would like to put it by way of an affidavit. List the matter again on 16th of October 2023. The affidavit be filed by 13th of October. Short one paragraph affidavit, just enclosing.
Article 39 for order.
Yes, service is complete, no, madam? Okay. The Learned Counsel for the petitioner submits that the writ petition has become infructuous as there has been a mutual settlement amongst the parties, and as such, she has instructions to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Item 40.
Now, the change, you have given the address of respondent number 3 before the Lozima court, but you have, in view of the other, directed to state by filing an interlocutory applications. Yes, you have to file an IA now. The Learned Counsel is granted 3 weeks time for the purpose of filing an appropriate application for amending the address mentioned in the writ petition of the respondent number 3. List the matter, list according.
41.
Service not complete.
Yes, sir. There are 5 was achieved the IO of this thing. So I would submit for this honorable board. He is in the active service of the government of the company. Can you please substitute the
IO. He's in, IO is the person by name.
Actually, what has happened? Here, we have paid for transferring a case of POPS for investigation to CBI. Because here, it is a CBI system made out, but I have placed some document, which says it's not a case of CBI. So we had split out, we released by name,
So 5 is by name
by name.
and 6, 7, 8, 9.
So far 9 is concerned, 9 has issued a legal notice to us immediately before this petition was filed from this.
Who?
9
Who is 9?
happened to be the wife of petitioner's son, that is a deceased person.
Okay.
So we had every doubt upon her. So what she did, after the death of the petitioner.
Understood, but you are to come, service upon 6, 7, 8, 9 is not done. You have to take fresh steps. The learned counsel for the petitioner submits that he would take fresh steps upon the respondent number 6, 7, 8, and 9 by way of registered post.
5 and 9 was already reflected.
Okay, 5 and 9. Nah? The learned counsel for the petitioner submits that he would take fresh steps upon the respondent number 9 by way of registered as well as usual within a period by next week. As regards respondent number 5, the learned counsel for the petitioner submits that the respondent number 5 was the then OC, IO, investigating officer of the Hatigao police station, who was investigating Hatigao PS case number 548/2018. The learned counsel further submits that he is presently in active service in the police department of the government of Assam. Under such circumstances, he would like to take steps through the office of the Director General of Police, Assam. The learned counsel for the petitioner is permitted to take effect steps upon the respondent number 5 through the office of the Deputy Director General of Police, Assam. This is the matter after completion of service.
9 is concerned, she's avoiding. The lawyer allowed me to find an IA. So prefer
That you do. Why should I pass an order? Why do I have to give you part? You are always at liberty. Yes. 42.
42. Okay.
Yes, whatever respondent number 4.
We have communication now with the respondent number 4 and we took 2 steps before, but
You are for the,
petitioner.
you have, how can you have a communication with the respondent number 4?
We do not know her whereabouts. That is what I'm.
Oh. Then whereabout means you don't know.
What if we use the address that was stated in the FIR and but
You are challenging some FIR.
yes, Lord, this is for washing of an FIR in Visakhapatnam.
Ah, that one. I directed it to be, oh, that one. Paper publication.
Yes, Lord.
You have to go for paper publication. The learned counsel appearing on behalf of the petitioner submits that he would like to file appropriate application seeking paper publication of the paper publication upon the respondent number 4 in her last known address. The liberty is given to file such application. List accordingly.
43.
Oh, You're obtaining a stay? You are having a stay?
No,
No stay? You sure?
Lordship, there is another FIR that was lodged in Guwahati. And for that, a final report was submitted saying that the allegations are false.
No, you have a stay as regards the Visakhapatnam thing. I think you have a stay. I remember that day. No, no, 42 days.
Yes, Lordship.
Yes, I remember. He is permitted to do so. The said application be filed by November 8th, 2023. List the matter again on 15th of November 2023. The interim order passed earlier shall continue till then.
We have received the instruction that the order has been complied with. The amount has been paid and we have the receipt.
This is pertaining to
The admitted liability of 14 lakhs.
the Learning Council appearing on behalf of the respondent number 2 and 3 submits that the directions so passed by this court in its order dated 8/11/2019 in WPC number 5805/2018 have been already complied with. And the amount of rupees 4,13,025 have already been paid to the petitioner. And petitioner naam to ki? I'll do so. Taking into account the above. In that regard, the Learned Council, Mr. So-and-so, appearing on behalf of the respondent number 2 and 3, have placed certain documents which shows that the said amount of rupees 4,13,025 have been duly disbursed to the petitioner. The said documents are kept on record and marked with the letter X. In that view of the matter, the contempt proceeding stands dropped. Yes, what is this contempt? Then somebody has filed. Then what? Has it been complied or not? You have not complied.
We have nothing to do. The content arises out of an order which granted status quo in favor of the petitioner not to demolish the building. That order was subsequently vacated by the Honorable Court. So probably the matter has become I don't know that part, but probably unnecessarily pending.
Why do you have instructions on this matter? You demolished. And the status quo order was the PWD a party in that.
And Liberty was granted to the PWD department to demolish the building. So after vacating this building.
And after, but demolition happened after or before?
That I'm not sure, madam.
Chalo. We'll have it next week. Get your instructions.
On that that very day, when order was passed, that is on 10/9/2020. Notification or a notice was issued, through which they began the demolition from that day.
But Mr. Council, as of now, that order has been vacated. So if the order has no longer is in existence, why are you asking for compliance? It is between you and you have already bought it before me. I have to only think as to whether it is there or not. You cannot now proceed or say that yes, at that point of time that I should punish him. For punishing, if there is anything, you may go to the civil courts. That is another thing. But why should this court go into all these things?
There's one order on 10/9/2020, and there are other orders on 8/11/2019, 9/2019, wherein similar things were started.
Did they demolish during the period when the status quo was in operation?
Also, the demolition happened fast. The first demolition, when it happened, the compensation was calculated, and later on, the extended part which was there, for that we got compensation, but largely for that, the demolition happened. Because of,
We are in contempt or writ.
but then,
There is an order for maintaining status quo, where the PWD was a party. Did the PWD demolish at the time of the existence of the status or pursuant it? Sure, I'll do it. Enough. Is the context. Yes. Which is the order? Till the returnable day, status quo as regards the land be maintained. Right, very well. So status quo, that you cannot be thrown out. And then what? What happened? Why are you, what is the contempt? What is the application you are saying? Copy of the order dated here was passed by the High Court. And approached this before this court asking him to vacate his land from the petitioner requested that the aforesaid area clinic was located in Manchester. What is the allegation?
also, on 10/9/2020, the order was passed. And that
What is the allegation, Mr. Counsel? Despite the two status quo order passed by and as regards to the land and the building here, the action taken by the was sheer interest. What did they do? The respondent authorities came into the residence of the petitioner and started dismantling the remaining portion of the building despite of repeated requests being made to them to refrain from demolishing the remaining portion of the building, and that a status quo order as regards the land and the building is already in force. We continue to mention here that the local council of the minister immediately conveyed the status quo order of this court same day by WhatsApp message to the Deputy Commissioner Jorhat and so on. Nevertheless, the Deputy Commissioner responded authority in blatant disregard of the said order proceeded in an illegal and continued dismantling the remaining portion of the building. Now tell me, are we only on this status quo as regards the land? Huh? Now, are you telling me on this order you have filed the contempt? Status quo as regards the land?
three orders from which we filed.
Yes, which one?
Annexure,
Annexure 1 is status quo as regards the land. The next order is interim order passed earlier shall continue till next day. Then for the answer, status quo as regards the building is directed to be maintained till 16/9/2020. Now this is an order which is, did the dismantling happen after 10/9/2020 till 16/9? When did the dismantling happen? The petitioner Atma is surprised on the same day that is on demand. The respondent authorities openly defined the sovereign authority. Okay. Who demolished? Huh? Who demolished? Huh? Where is your statement that who were the persons who went there? No, forget about it. Where is your statement in your petition? This is the criminal, this is the quasi criminal proceedings. Can you do so? Tell me. No. I've heard the learned counsel. The instant repetitions reveals the instant contempt application has been filed for non-compliance to the orders dated 8/11/2019, passed in WPC number 8249/2019. As well as 10/9/2020, passed in WPC number 3450/2020. A perusal of the order dated 8/11/2019 in WPC number 8249/2019 shows that this court, while issuing notice of motion, directed that till the returnable date, status quo as regards the land be maintained. By the order dated 10/9/2020, this court further in WPC number 3450/2020, this court further directed that the status quo as regards the building be maintained till 16/9/2020. It may, however, be pertinent to mention that the interim orders which were being passed were subsequently vacated by this court. Vacated? Huh?
69 itself.
On 16/9/2020, both.
No, 3450.
It is, however, relevant to take note of that the order, that the interim order which was passed on 10/9/2020 in WPC number 3450/2020 was vacated by this court on 16/9/2020. In the backdrop of the above, a perusal of the contempt application reveals that on 10/9/2020, the respondent authorities, defying this court's order, came to the residence of the petitioner and started dismantling the remaining portion of the building, despite repeated requests being made to them to refrain from demolishing the remaining portion of the building, and that a status quo as regards the land and the building is already in force. It is, however, relevant to mention that from a perusal of the set of allegations made in the contempt application, there is no specific, the said allegations are general allegations without assigning, without stating who of the respondents in the instant contempt applications were present on 10/9/2020 and violated the order passed by this court on 10/9/2020. Taking into account the above, this court finds this not to be a fit case for further proceedings with the instant contempt fit case for further proceeding in the instant contempt further proceeding. Accordingly, the contempt against the respondent stands dropped.
45.
Hmm.
Professional 923 within there,
Hmm.
the service to the respondent number is not completed.
Done. 45 completed. Okay, service is complete. This is the matter for admission after the puja holidays. 46.
Okay.
Complied.
Also, I am hearing for the sole respondent or this content, and highway.
You're not complying. Okay, Miss D. Bora. Mrs. D. Bora appearing on behalf of the sole respondent 6 for an accommodation of 3 weeks for filing affidavit on behalf of the sole respondent. List the matter again on 22nd of November 2023.
47.
Yes, you are not filing the affidavit. Yes, Mr. P. Hendik. You're not filing affidavit? Huh?
The next.
Okay, order issue. I passed some order. Oh, snake is naked. You are filing in next week? When? Mr. P. Hendik, the learned counsel appearing on behalf of the PNRD, submits that he is going to find that the PNRD department shall file the affidavit. List the matter again on 29th of November 2023. The affidavit be filed by 21st of November.
Okay.
List the matter for admission on 29th of November. Affidavit be filed by 21st.
Okay.
Service complete. Service being complete, list the matter for admission.
49.
Huh? They will do what? Let us come up for admission, then I'll. Hmm. So respond number 3 and 7 has been deemed.
47.
Hmm?
3 and 7.
So service is complete. Service being complete, list the matter for admission immediately after the puja vacations.
50. Stay operating. Stay operating.
Okay, list the matter for on 6th of December 2023. Interim order pastor shall continue till then.
50.
No, yes. I did not issue any notice here. Ah,
Sixth of August, it has been paid.
what was your age? Age of the victim? Age of the victim is how much? Below 8 years, 18 years. Huh? What was the age of the victim? Main petition. Oh, ho, ho. No, 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 no. You are entitled to only 3 lakhs because the person died on 28th. Full stop. Ah, okay. Nothing remains. You have got more than enough. Ah, I've seen it. Full stop. Because I can do him contempt on this. The instant contempt application has been filed. For non-compliance with the order dated 4/3/2020, passed in WPC number 7721/2017, wherein there was a direction to take a decision for release of ex gratia grant to the petitioner in terms with the notification dated 15/11/2014. It was further mentioned that the entire exercise shall be completed within a period of 3 months from the date of receipt of the certified copy. It is further seen that on 16/3/2020, the petitioner duly submitted the order passed by this court. However, as the order was not complied with, the instant contempt application was filed. During the course of during the pendency of the contempt application, an interlocutory application was filed by the petitioner on 21/7/2023 to implead the new incumbents as the contempt number 3 and 4 to the accompanying contempt to the instant contempt application. The said interlocutory application was registered and numbered as IA number 2016/2023. This court on 22/8/2023 directed the Standing Council of the Revenue Department to apprise this court as to whether the applicant had been paid the entire amount of ₹5 lakhs to which the applicant is entitled to in terms with the notification dated 15/11/2014. Today, when the matter has been taken up, it has been seen that the applicant, it is seen that the son of the petitioner, the son of the petitioner expired on 22/11/1998. Under such circumstances, the applicant, the son of the petitioner being the next of the kin, grandson, no? The grandson of the grandson, son, grandson, the petitioner. It is during the course of today, it has been seen from the document which have been placed before this court. Today, when the matter has been taken up, Miss N. Bordley, appearing on behalf of the Revenue and Disaster Management Department, has apprised this court that on 6/8/2023, an amount of ₹3 lakhs have been sanctioned and also disbursed to the petitioner. It is also seen during the course of from the communications which have been placed on record that the victim was the grandfather of the petitioner. Grandfather? And the incident had taken place on 22/11/1998. was taking into account that the compensation to be paid in terms with the notification dated 15/11/2014 categorically mentions in the notification itself that only those that the revised rates shall only be applicable in respect to incidents which had occurred on or after 15/11/2014. The petitioner have been granted the compensation in terms with the government notification dated 27/8/2009. The said documents have been kept on record and marked with the letter X. Remain to them. In that view of the matter, as the directions passed by this court in WPC number 7721/2017 by the order dated 4/3/2020 have been duly complied with. Nothing complied with. The contempt proceeding stands dropped. Taking into account the order which have been passed in the accompanying contempt application, not the incident I also stands closed. Legal representative of the respondent by Iman, right? 51, 54, so many matters, right?
51 to 54.
Yes. Ate Iman.
After item 51,
Ah,
to date expired. This is our to date expired, item 51.
then
Then his legal decision is not on the body.
why so many applications? Only one.
Only one.
Here is 51 to 54 view here.
Why? It is on both decisions.
In all four petitions,
In present petition, it is not to date expired. And then petitioner in item number 53 is petition of 20. Why?
and what about the other two? These are all within time. When did the petition number 28 die? And it's survived by? Hmm? Digonto? Is the applicant? Where? Where is your name? Or Digonto Pukon? Okay, I'll back you. I give you conditions. Hey, to substitute coil. Digonto Pukon instead of in lieu of AR. Both orders. Even what is that? Response also. Item number 51. A Hussein. This one. I. You can allow you, huh? Okay. What is 52? Unnecessarily it has come. 53. I is there. The same. Same person. You can allow you separately, huh? These are 2015 matters. Yeah. These are admitted matters or what? Not admitted. Our main petition order to list the matters on 14th of November for final disposal, taking into account that these are all old pending petitions. So 51 to 54 done. Now who is 55? You can allow the I. 55? Oh, yes. What is this?
The respondent number 5 passed away. We have filed a petition.
Oh, 55 Kundu? Who is respondent number 5? You? Amal Krishnan Kanu. What is this dispute? Isn't that the gun factory one?
Yes, yes.
What is this matter about? And when did he expire? The instant application has been filed by the petitioner. Petitioner, you are for substituting the legal heirs of the respondent number 5 who had expired on 6/3/2023. It is seen from a perusal of paragraph number 2 that the respondent number 5 is survived by the legal representatives whose names appears in serial number Roman 1, 2, 3, 4, and 5. And they have been arrayed as the opposite parties to the instant application. Taking into account that the right to sue continues against the performers, against the legal representatives of the respondent number 5, this court substitutes the opposite parties herein as in place of the respondent number 5. I accordingly stands allowed. The registry shall make necessary correction in the accompanying with petition on the basis of the instant order and shall update the same in the CIS. It will petitioner issue notice upon the newly implemented, newly substituted respondent number have been substituted as respondent number 5A, 5B, 5C, 5D, 5E. It will be in the accompanying petition. Accompanying petition, in view of the order passed in today, order dated so and so, in ISC number 2, line 22/2023. Let notice be issued upon the newly substituted respondent number 5A, 5B, 5C, 5D, and 5E. The petitioner shall take steps upon the said newly included respondents by way of registered as well as usual newly substituted respondent within a week. List according. Yes, 56. 1.3 died.
Earlier 1.3 died, then 1.1, 1.2, and 1.2.
And now what do you want to make it? 1.3.1.
1.3.1.
What is this? How old is the petition?
2016.
You have rendered the petition in a similar matter, like what is this matter about?
Regarding payment taken from land under the GMC compound without any acquisition and without any compensation. Requisition grant was obligated. I am already proceed on behalf of this one legal years of 1.3 and earlier council has there for the
1.3.
I am again company on behalf of the legal years of 1.3.
Petitioner is not here.
No, no.
Who is the petitioner?
Petitioner proceed on originally one on her death, her.
No. Petitioner's lawyer is who?
I have made them perform.
Huh? Interesting matter.
As petitioner number 1 and 2 are my brother-in-law and sister-in-law. They have not signed the wakalat. So I cannot if we are.
So for petitioner, there will be two sets of counsels.
Because originally one petitioner was there, but the original counsel was different. And then she was.
Madam, let me fix this matter again on. Let me fix this matter. Huh? No, I understood, but then also we are taking at 5:30, so we'll fix this matter in their presence on 10th at 2 p.m. List the matter on 10th at 2 p.m. because let us also have a. Yeah.
I think all the petitioners advocating sign this so that we can put together.
Yes, because otherwise there will be a later on a problem.
But their point of contact, but after submission of registry is not correcting the cross title nowadays. Due to that notification, or she find hand correction is not allowed nowadays. So we have to file amended cross title. So we have direct the councils to file amended instead of registry to direct the.
Yes.
No. What we are directing, I am directing the registry to correct the constitution. They will do it. And also update in the CI. Huh?
They call the, after this notification, by hand, they cannot correct the cross.
No, you cannot do it.
But they are also denying. In one of my application, your lordship, complicated. Then they called me and then again I have filed my amended cross title.
No, you may file an amended memo parties. That you can file it. This is also done. But then you see, these are things, otherwise there is no problem with the head. Only, everything can be done. Only thing which cannot be done is what the problem why this notification has come is because every time what has happened in the court, somebody corrects it. And we pass an order. That is why today there were many matters where I asked them, you file an IA.
That was not cleared in the notification. Notification says all handwriting corrections are not allowed. So, lordship, the registry is also not correcting the process.
No, that is okay, that is different, but the reason what is happening without an application, if we do, there is a problem of that. And not only the problem, we sometimes are saying we impeach somebody. Now the problem what happens in the cause title, or you see, the moment you are filing nowadays, these are all updated in the CIS. Once it is updated in the CIS, this will all along remain in this manner. And your name would never appear anywhere unless that is updated. Therefore, my orders clearly says that update in the CIS. That is the main reason. Others are all peripheral. These somebody wants to put something, these are all we happen at time to time, but actually that is it. Okay.
ये साहब का टाइम दिया है